A very good morning to all the viewers on the Facebook Live platforms of Namibia Media Holdings. That's of course Namibian Sun, Republican, Algemene Zeitung, Windhoek Express, as well as Irongo. My name is Denver Kisting, and with me is my colleague Jemima Bekes. Good morning, Jemima.
Good morning, Denver. It's an exciting morning today.
It is indeed an exciting day. The former independent presidential candidate, Dr Panduleni Itula, is of course bringing a challenge about the 27 November 2019 election results pertaining to the presidential leg of those elections in the Supreme Court in the capital this morning. You spoke to an analyst earlier this week, Jemima.
Yes, Denver. I spoke to Dr Ndumba Kamwanya this week, and he gave his brief overview and insight on what this case may hold for the political future of this country.
Indeed, a landmark and a very important case, although we know that it's not the first electoral challenge.
Absolutely.
I also spoke to Ms. Emma Theophilus. She's a youth activist and a law graduate, about the prospects of success of an electoral challenge of this nature. So that's what we have for our viewers today. Please stay tuned.
We lose ourselves in the spirit of things. We lose our sight when we put our trust in things of this material world, of things that fade away. Yet we keep coming back, 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 keep coming back.
Viewers, my name is Jemima Bekes. We are here with Dr. Ndumba. He'll give us his views on the Supreme Court that was brought by independent presidential candidate Dr. Panduleni Itula, and he's seeking a nullification of last month's elections. Dr. Ndumba, thank you for having for being with us this morning. In your view, can you please explain what the crux of this court case is? Can you also point out to us? Obviously, a lot of this court case hinges on the lack of a paper trail. In your view, why is a paper trail critical in terms of the transparency and integrity of this election? And then also, what do you think will the impact be should the court order for the nullification of the election? What do you think? What will be the impact on this election, but not only this election, but also the current government that is in place?
Thank you, Jemima, for having me. Let's say that tomorrow is the day of Armageddon, where the last battle of this court case. I think everything will depend what will be the judgment. I don't think we'll hear more about it after that. So tomorrow is a battle from both parties, representing each party that is involved in that election, for their lawyers to make the case that whether the election must be nullified or it does not warrant it to be nullified. Well, the issue here, I think it's going to boil down to evidence, and we have seen it when Dr. Itula brought the case about the before the election. It was also, I think, dismissed on technicalities, but more in terms of the evidence. So here, really, the burden is on the applicants to provide concrete evidence that will satisfy the court before they can make a decision whether they can nullify it or not. So in my view, I think that it is going to be a tough case for the applicants really to provide that evidence, but we don't know what kind of evidence do they have apart from the paper trail, and also apart from the fact that they have mentioned that there were some irregularities. But courts do not operate like that. Irregularities in itself do not necessarily guarantee that the court will agree with the applicant. So it will depend to the nature of that irregularities for really for the court to heed the applicant. So really we will hear what kind of evidence the applicants have in this case. That will make or break the case itself. But I should also mention that what is important about this court case is the democracy, our democracy, and the process of laws. That in other countries we will not have been sitting here and talk about this case. We will have been seeing people, killing each other and beating each other in the streets. So it's very good for our democracy that we are a country of laws, that if you feel aggrieved that we follow the laws and put our case so that we can be heard. So in that context, it's a win for our democracy, and it also shows that we are a maturing democracy where you go and put your matters before the Supreme Court to make a decision.
Speaking about democracy, how critical do you think, obviously, like I've said, a lot of this case hinges on a lack of a paper trail, which obviously Dr. Panduleni is questioning. Why, in your view, is a paper trail so critical?
Well, it's very critical because with the current voting machines that we have, it's difficult really to verify. You don't know. I'm sure you voted, and I voted as well, but we don't know whether my vote or your vote really went to the person that you voted, or it was really counted. So that's why paper trails are very important, because they can give evidence, in moments of doubts like what we are facing now. It could probably been resolved easily by looking at how people, voted and all those kind of things. So it is critical.
Yes.
But I should add that the absence of paper trails does not necessarily mean that the election was not free or fair. Yes.
But it just adds to trust.
Yes, the trust issue and the credibility aspect.
Of
yes.
course. Now, before we say goodbye, can you just please point out to us what would obviously the full bench of judges determined that it was flawed and that these results should be nullified. What impact would this have on our results right now, and obviously the past election which saw this current government in place? Yes.
Well, there are many aspects to look at it if they nullified the whole election or partially or part of it. So of course, obviously we have to organize another election to do a rerun, and that comes with a lot of logistical arrangements and financial complications, and also remember that we are also having the local and regional elections scheduled for this year, so that add up to the complications of the situation. But the more impact that I seen is the response of the voters. And remember that the country is divided. If you look at the votes that were cast last year, so the response might be the issue of whether they will agree with the court or they will not agree with the court. So we have to also to be careful on that aspect. It might put us into chaos if the ordinary voters in the streets do not accept. But under normal circumstances and under country of laws as we are, that we have to accept the judgment of the court, whether it's for or against it. And there are also other mechanisms that are put there, maybe to reappeal and all those kind of things. I think that's the best way to do in this case.
Thank you very much, Dr. Ndumba,
Thank
for
you.
being with us here. And there you have it. Let us see where the dice fall for us, this Namibian country of the brave. Thank you very much.
Joining me is Ms. Emma Theophilus, youth activist and law graduate, to unpack the prospects of success of the electoral challenge, which will be heard by the Supreme Court, brought by the former independent presidential candidate, Dr. Panduleni Itula. Good day, Emma.
Good day, Dema. Thank you for having me.
Welcome.
Thank you.
Emma, I'd like us to start at the very beginning. What exactly does Dr. Panduleni Itula want the court to do? What is this matter all about?
Okay. No, Denver, as a former presidential candidate, Dr. Itula really wants the Supreme Court to, to set aside the election of especially the presidential election of November 2019. He would also like to the court to set aside the use of the EVMs in that particular election. He would also like to set aside the results of that presidential election and also to conduct a fresh new election with no delay. That is exactly what he wants the court to decide in his favor.
Should the court decide in his favor, those requests and those prayers have far-reaching implications?
Oh no, they definitely do. I mean, the court, I think, in previous court challenges, or even anywhere in the world, takes such challenges very seriously because the financial implications, the implications it has on the credibility of institutions that hold elections, for example, in this case, the ECN, the implications on the democracy of a country and how further elections would then be conducted all have some serious consequences on every nation. So this would have not only a time consequence, but also a financial one and an authenticity one on institutions that are supposed to uphold the principles of democracy.
What does it say about the strength and access of our institutions for an aggrieved citizen to be able to bring such a challenge?
Oh no, I think, to be very honest, I think our legal system and judicial system has time and time proven that they can be very competent in interpreting our laws, and that's, I think, many people sometimes do not understand. I mean, your will is not always the law, and that the law stands in a particular way to influence order in society. So it has shown over time to always interpret the law in such a way that it allows for the law to continue functioning and to continue functioning for its citizens. So I think we have a credible judicial system, and so the Supreme Court is the highest decision-making body in our land. It has the ability, for example, to change any law, including the Constitution, and therefore I think this would be a landmark decision.
Notwithstanding the fact that the individual's will, as you rightfully said, doesn't necessarily amount to the law, the individual still has the right to test whether his will amounts to the law.
Yes, definitely, and also just really to test whether the laws are still, relevant, if they still speak to the needs of the Namibian people, if it still speaks to the times that we live in today. And that's a very important component, because Article 18 allows any citizen, institution whatsoever, who feels aggrieved by any tribunal, institution, or office of government to then challenge any decision. And of course, with the application, you will see that many sections of the Electoral Act are being challenged. Many modus operandi of the Electoral Commission of Namibia are being challenged, and many of the powers they have as per the Electoral Act are being challenged. So this really has a lot of issues in it, but primarily, it allows any individual who feels aggrieved to approach the Supreme Court and the Supreme Court to decide objectively on what the results should be.
Just to take one slight step back, Emma, we do know that Dr. Panduleni Itula, at 2 occasions prior to 27 November 2019, did try and convince judicial institutions, for lack of a better word, once the election tribunal and in another instance the High Court, to stop the ECN from using EVMs, and he was unsuccessful in both instances.
Yes, I mean, that's quite interesting, because I really think that's where, this challenge stems from. I mean, Dr. Itula first brought his application to the Electoral Tribunal on the 13th of November. He brought it on an urgent basis, and his asks were basically for the court to declare that the 2019 Presidential and National Assembly elections not utilize EVMs because they were faulty, that some have been missing and therefore could be used in this elections, and that could tamper with the results. And in that instance, the court really had to adjudicate on 2 issues, and that is the first instance whether the application was urgent and whether or not the matter of fact and the law was one the court could adjudicate on. So in the first instance, the judge who presided over the matter indicated that it was not urgent because, remember, this application was then heard on the 19th of November after the seagoing personnel and men and women in uniform had already voted on the 13th of November. So that already killed the urgent application, because even the judge said he knew, or the applicant knew, that the EVMs were going to be used already in October when the ECN had written to him to say he has become a successful presidential candidate, and therefore these were the procedures going to be used to run the elections. And then he appealed that decision because the acting judge had also said that the Electoral Tribunal did not have the jurisdiction
in any event to hear the matter.
Exactly. And that the High Court in this instance was the right organ of state to actually hear the matter.
And then he went to the High Court the evening of the 26th of November 2019, on an urgent basis, hours before the the polling stations were scheduled to open on at 7 o'clock on the 27th.
Exactly.
And that urgent application was equally unsuccessful.
And it was dismissed. And then I think, well, perhaps I would say, for example, in this current application before the Supreme Court, again also comes at a very awkward time, because just yesterday we had our by-elections where EVMs were used in the local and regional authority elections, and because whatever decision, let's say for instance, the Electoral Tribunal had jurisdiction and did decide that the EVMs were not supposed to be used, that would have had an effect on any other election subsequent to that, and that would include this by-elections. So again, this decision by the Supreme Court would have far-reaching consequences on the just recently elections we had in the by-elections.
Because as the highest court in the country, its decision would be binding.
Exactly. Would be binding on previous elections as well as future ones. So really it comes at a very interesting time that this challenge is being made even after 2 unsuccessful court challenges already.
Yes, Emma, what we do know is that election challenges are not new to the land of the brave.
Not at all.
What is the discerning factor about this particular challenge? What makes it different to the previous ones?
Yeah, I mean, the first, or to my knowledge, the first electoral challenge we had was that in 2009, when the Rally for Democracy and Progress and other political parties challenged not only the results but the election itself of the 2009 27-28 November elections, and there EVMs were not used. It was ballot papers.
Yes.
So that is
all traditional ballot papers.
And people still had a problem with ballot papers. And now you have this current application, and the applicant is saying, look, scratch the EVMs, let's go back to the ballot papers. And that was also an issue in the 2009 elections.
Or what I think he also says is that there should be a verifiable paper trail.
Yes, that's an alternative.
Yes,
that's an alternative to say, which also really counts as a ballot paper, because what the paper verification, voter verification paper trail does is, once a voter casts their vote on a EVM, sort of like an individual paper prints out to say, okay, this person voted for person X or voted for party X, and then that is folded and then put in a ballot paper.
So just proof.
So it's just proof to say that whatever the EVM produces as the final results, there should be some verification or double end result of physical, evidence that is a reflection of what the EVM has recorded.
Yes, as we move to the prospects of success for this challenge, I think part of what he is saying that the ECN is unable, and they did at some stage make this undertaking that should a court case emanate from the 27 November 2019 elections, they would be able to prove that Denver Kisting voted for this party or for this candidate at this polling station. It now appears that they're unable to do that.
Yes.
And that is why he wants to create the impression that there should be doubt about the credibility of these elections.
Exactly. But, this is for a nation that lives in a democratic state that, I feel like when growing up, they say, look, your vote is your secret if you choose it to be your secret. That also goes against, for example, privacy of individuals and who they wanted to vote for. But even in the event we have a paper trail or whether we have ballot, that still also doesn't prove that this person voted for this particular and so on. And I think trying to force the hand of an institution that's supposed to protect the privacy of voters, for example, in this regard, I think it's a bit unfair.
To breach that privacy.
To breach that privacy, I think it's a bit unfair. But also, to what lengths are you willing to go to really prove that, person A voted for person X or party X, and how that would have any far-reaching consequences to the results? Because then at the end, you are doing an upweigh, whether the privacy of an individual should then be weighed up against the results that you then contend are not true. As long as...
Or could be untrue.
Or could be untrue.
Yeah.
So it really comes down to the fact of if there is real doubt of, for example, dysfunctional EVMs or tampered EVMs or a paper trail that would then verify results, I think that should be based on evidence. And I think that would be a challenge in this Supreme Court case because the applicant, Dr. Itula, still could not prove that in his first application with the Electoral Tribunal and even subsequent to the appeal in the High Court. So that's really, I think, would be the crux in him convincing that full bench of the Supreme Court, which a full bench would mean that it's a serious matter and that you have up to 5 judges really going deep into the law and adjudicating on the credibility of your application would require a lot of evidence.
Yes,
prove.
Speaking of the full bench, we understand that there will be 4 Namibian judges and 1 ad hoc judge from South Africa hearing the application, and that includes our Chief Justice.
Yes.
We also know that as far as Supreme Court matters are concerned, it's not always that a full bench hears a Supreme Court case.
Yes. Usually in instances like this, let's take, for example, any application. Let's say you apply to the magistrate's court around a matter and you don't succeed. The next court to then appeal to would be the High Court. And after the High Court, you can then appeal to a full bench of the High Court, and then after that you can appeal to the Supreme Court and so on. So this is sort of like the final stage. The full bench of the Supreme Court, you can't go any further than that. So once the Supreme Court, this full bench decides on A, it's A. And once it decides on B, it's B. Only it can later on decide otherwise if you appeal to it. But then again, it's your last resort. So this just shows the gravity of this case. It just shows the seriousness in which the judicial system is taking electoral challenges of this nature in today's day and age, and that this would really set a tone of how we conduct elections in future in the land of the brave.
I'm sure that everyone has their opinion about Panduleni Itula, and a lot can be said about him. But my sense is that there's consensus that this is a tenacious, relentless gentleman.
Yes.
He's also acquired the services of a senior South African advocate with more than 40 years experience, Jeremy Gauntlet, QC, SC. What does that mean in terms of how he views this very seriously?
Yeah, no, I mean, it like you said, he's tenacious and relentless in this to really try to set a precedence on how elections are. One could commend his commitment to this, because whether he's successful or not, it would create some type of certainty in the minds and lives of Namibians to say either that yes, the EVMs are trustworthy, or no, they are not trustworthy. So whatever way you look at it, on whatever spectrum you stand, it's still a very important thing for our democracy. It means our democracy is alive and well, and that it is thriving. So this really shows that anybody can go to court to challenge anything they feel aggrieved about, and that the court will adjudicate on it and then make a decision on it. Whether the decision favors you or not, it's still a result that we can be proud of as a nation, that our democracy is alive and well and it is thriving.
Emma, as we wrap up, earlier this week there was concern expressed as far as the by-elections are concerned. Why, when there's a pending challenge in the Supreme Court, which is the matter that we just spoke about, are EVMs that are the bone of contention being used in these by-elections? Can't we wait with the by-elections until such time as the Supreme Court has pronounced itself and then have these by-elections?
No, I think what the nation needs to understand is that everything, for example, the Electoral Commission does is governed by law, by procedures and by decisions that were made and gazetted by government. So therefore, the Electoral Commission, per the Electoral Act, is mandated to carry out elections 90 days after a vacancy has opened up. And that is very crucial. If they do not do that, it means they then are breaking the law.
Yes, and they're not in compliance with their own act.
Exactly, and they're not in compliance with their own act, which is like, okay, if you can't follow your own laws, like, can you be really trustworthy? So it's really a legal requirement for them to conduct these by-elections, regardless of whatever is happening, including this Supreme Court application. So that is a non-factor when it comes to them then following their rules and procedures and their law in conducting these elections. I would also like to add that whether opponents of the EVMs or not, whether it's an independent candidate who's challenging the authenticity in the previous elections, or other pressure groups that feel that the EVMs are not credible, it's interesting to see that there was celebration, for example, in especially urban areas when the independent candidate won that election, and they were able to claim that victory and say, we won this election. But in places where they didn't win, they would blame the EVM. So I think there needs to be some type of consistency. Just even now in the by-elections, the same pressure groups would say, look, the EVMs are not to be trusted, the elections are being rigged. But when their candidates win, all of a sudden, the EVMs are to be trusted because their candidate won. So I think that we need to be consistent in what we're advocating for. And unfortunately, the by-elections could not be stalled because there's a Supreme Court application. The ECN is mandated by law and needs to follow its laws and procedures. There's no way around that.
Emma, thank you very much for your time.
Thank you so much for
we
having me.
look forward to seeing what transpires from this matter.
I think every Namibian would be on the edge of their seats to hear this decision.
Thank you very much.
Thank you.
There you have it, Ms. Emma Theophilus, youth activist as well as law graduate, talking to us about the prospects of success which Dr. Panduleni Itula has.
May it please the Court, my learned friend Mr. Pelser and I appear for the 5 applicants in this matter, instructed by Ms. Elise Ngula Co. for all 5 applicants.
May it please the Court, I, together with Dr. Akwenda, will appear for the first and second respondents, and I also appear together with Mr. Akwaya for the third and fourth respondents.
Thank you, Chief Justice. Justices. Chief Justice, the parties in this matter have agreed on a few procedural points I should perhaps mention and get out of the way, subject, of course, to the court's approval. The first is that there is an application for condonation by the respondents in respect of the late filing of a notice, which we don't oppose. The second is that the parties are agreed that there should be one argument aside encompassing all such issues as they wish to argue. The third is that we shall seek to argue an hour and a half aside, allowing thereafter a short period at your determination in relation to a reply. I believe, Chief Justice, that encapsulates the basis on which we would wish to proceed, and if the court would permit me, and subject perhaps to my learned friend just moving then his condonation application, I would proceed.
Okay. According to Judicial, Chief Justice.
Thank you, Thank you, Chief Justice. Chief Justice, both sides have filed, as the court knows, detailed heads of argument. We, for our part, do not intend to try to repeat those. We know it's not the practice or desire of the court that counsel should do that, but should take them as thoroughly read and understood by the judges. So the fact that we don't refer to anything in particular in various places is, with respect, not to give rise to any inference. We stand by that argument. What we wish to do, as believing it to be helpful to the court, would, in the light of particularly the respondents' heads of argument, to go to the central issues as they have emerged in this matter. First, however, I should say something very shortly by way of introduction. We all know of the enormous importance of this case. The court sits as a full court, as a silent recognition of its importance. And its importance relates to the fact that already the fourth paragraph of the preamble to the Constitution refers to the rights which were denied to the citizens of Namibia before they attained independence. One of those rights, as regards universal equal adult suffrage, was the right to vote. It's crucial because it finds expression through Article 1 in the reference to democracy, and it finds a far more explicit reference through Articles 17, 28, and the very important little chapter which was added to the Constitution, in particular Section 94B, dealing with an electoral commission and remedying a defect in the original Constitution, which was to have an independent, impartial electoral body which would stand aside from other arms of government. So, all before you would be agreed of the importance of the matter with which we are seized. You would expect from us at the outset, before going into our argument, we would think to do two things. One is to try to snapshot as shortly and tightly as we can our core argument. The second then is to explain to the court the sequence in which we would seek to develop that. The core of our argument is this. It is an admitted fact between the parties, and there's so much in dispute, but the crucial things are not. It's an admitted fact that there was no paper trail conducted in relation to the 2019 presidential elections. And you find that admission several places, but most shortly put at page, I think it's 234, line 5. And 234, line 5. So this is not a case where you might be confronted with an argument which in the old language would go to, as it were, substantial compliance. We didn't do X as X is described, but we did something which we say should be accepted by a court as good enough for X. And I'll come back to that because there is a slightly, with respect, muddled argument which suggests that the Commission could devise alternative means which they say were good enough. The other crucial aspect is to deal with and get out of the way, because I don't know if members of the court, like me, are obliged to turn progressively to their children, and in my case grandchildren, to explain to me how things work. But what is this paper trail that we go on about the papers, go on about so much in the papers? To confine dispute between the parties, we'll go only to a document of the other side. It's at page 199, and it's one paragraph, which we invite the court to accept as a perfectly adequate, simple description of what is meant by this shorthand paper trail, which, as you know, has a longer name, VVAT, Voter Verified Audit Trail. And this is the paragraph. The manner in which this happens, i.e. that there is a paper trail, is that after a voter presses the green button on the ballot unit of the EVM against the chosen candidate or party or organization and it should be casts the vote by pressing the red register button. The VVPAT prints a slip containing the name of the candidate and the symbol, displays the slip for 7 seconds on the VVPAT window for the voter to see, and drops it automatically into a sealed box. The VVPAT machine is kept in the voting booth together with the ballot unit to protect the secrecy of the ballot. Where this goes to, justices, is this. And members of the court would have had the experience of voting electronically. They wouldn't have had the experience, this is why we're here, of the voting trail. But what this is explaining is that effectively there would be a glass or perspex box next to what you are pressing, the red and the green buttons, and two things would happen. One is that you, as a voter, and voters are, in the nature of things, skeptical, worried, concerned about voting, you would not just push a button and know, will I push that button, but you would see an emanation in print of your vote. It would actually come up for 7 seconds that you could look at it and see, yes, I did vote for X or for Y. The second thing is that would drop. You wouldn't take a piece of paper home and show your family or anything. It would drop into a sealed box. And where this goes to is a very fundamental issue of departure. It's not a dispute, it's a legal dispute perhaps, but it's not a factual dispute. And that is this. The insistence on the other side of this case is the reason for a paper trail is simply to reassure the voter. And that is only part of it. It's one of the things. As my own clients have explained to me, you may get people who come from a remote area who may not be attuned and who are even more suspicious than I am as regards technology. That they can see for themselves and verify for themselves the person they voted, that they can see actually by pushing this button, I have voted for X. That is what our learned friends rely on and the other side rely on. The comfort, as it were, for the voters, and then they say that you can get it in other ways. They're missing out the second point, and that is that that paper drops into a sealed box so that if there is a dispute as to regards to the function of that machine or to the outcome at that polling station, you have a separate recordal so created to be able to verify what the machine is saying. And that we shall be showing you is exactly the road that other countries went down. And in particular, the Indian Supreme Court held, you must have that. You must have it, and it's for these two reasons. The German court, the Constitutional Court, has held, you must have it. And in Kenya, there has been the same principle adopted, and we'll come back to that. So that is what this case is about as regards a dispute on a paper trail. But what is the core? And I promised that I would try to say in a few words, what is the core then of our case? We say ultimately there are really just two issues. They're the ones we try to identify at the beginning of our heads, but let me summarize it this way, colloquially, as clearly as I can. We say that Section 97 of the Electoral Act was enacted as a provision. It's got sub-provisions, or if you like, colloquially parts. But it was enacted by Parliament as a provision. We say that its thrust was that Parliament said Namibia can be the effectively first country in the region to depart from manual voting. It can, if it is implemented by the Electoral Commission, we'll come to that, it can have electronic voting, subject to there being the contemporaneous check and balance of the paper trail. And we say at the heart of this matter lies the fact, and we don't impugn the integrity of the minister or the commission, we say it was misguided and simply what the case is about is acting beyond powers. But we say that what the minister did, given the power that he has under Section 209 of the Act, to implement provisions of the Act from time to time, he bisected the baby. He took that integrated provision and implemented two sub-provisions on it. He didn't implement the provision. And he left out the check and balance, which was effectively that 1 and 2 are subject to there being a simultaneous paper trail. And an interesting thing, and I can draw your attention to it immediately, there's no argument by our learned friends on that subject to aspect. Our reliance on the cases which go back to Mawani and as they've been adopted in this court, that subject to is a proviso. And what happened in the enactment of Section 97, it's a relatively modern statute of 2014, was it said 1, 2, 3, 4. And 3 talked about, made it clear that the enactment, or the implementation of paper trail was subject to this check and balance. Can you imagine if Parliament makes a provision, for example, under the Criminal Procedure Act, which in the new simple style of legislation could be subsection 1, a policeman of the rank of whatever and above may arrest a person, full stop. 2, the power under 1 is subject to the policeman forming a reasonable view that a crime has been committed or is about to be committed. And there's such a provision in the Act that the minister can implement provisions as is when he, in line with Justice Chaskerson's judgment in pharmaceutical, which our learned friends rely on, they think it's right, it's time, we've got all our ducks lined up, we can do it. But what he does is he just says, I implement the arrest provision. I leave out the safeguard. The court, we would say, no. When there's such a power saying the executive may, in its judgment, which obviously has to be a judgment that this is based on proper considerations, it's the right time and the like, it would have to take the provision, if it's an integrated provision, and implement it. Or it would have to say, no, it's not right, it can't be done yet. What you can't do is have the executive choosing those parts of what Parliament has enacted to be the law. And the key question would be, what do you make of the word provision then under Section 209? And we say that provision would mean sensibly interpreted. What was Parliament trying to provide? Parliament was trying to provide for electronic voting. It did so in one integrated provision. It did so with conditionality. That conditionality would have to be respected, and it wasn't. Now, if we are right on that main argument, then we submit there's only one other issue in the case. And that issue is the question of relief or remedy. Our learned friends have flirted with the idea that you should remit us to the High Court, because they say some of our prayers belong in the High Court. That is one thing they say you should do. They say also that if you are with us on the main argument, all you should do is give the applicants in this matter a declaratory order. So it would be declared that the conduct of the election on that basis was not compliant with law. But don't do anything more. And what they say you should do is, first of all, in the heads of argument, it's spelled out more, you should do it only prospectively. So what, in 5 years' time for the next election? And our argument there is a simple one, that this court in Cran, in the judgment of His Lordship Justice Smuts, it was Cran. Oh, was it the Chief Justice? I'm sorry. The Deputy Chief. I'm sorry. I'm incorrectly casting copyright. Yes, the Deputy Chief Justice said this. If the court finds, and I paraphrase, a provision unconstitutional, then the principle of objective unconstitutionality arises. The normal or default position is that that which was purportedly done is not valid. And that is so for a very important reason. The Constitution has not been complied with. The law has not been complied with. But the court has a tempering or mediating power that in some circumstances it can say, no, look. And Justice Mkabinde will remember in South Africa the cases like JSC Sapila, where there was a half-built prison and setting aside of a tender and the like. And the court says, you're quite right. Or in Orpay, there may be an instance of saying, you're right, this is unlawful. But if we take certain circumstances into account, as in Cran, the order we give is a more nuanced one. We say, for the reasons we've come to argue, that the case that is put up in this matter is this, that it would cost money to have another election. Yes, it would. In Rally for Democracy, this court confronted that argument. And this court in Rally for Democracy said that is a consequence often of, unfortunately, executive or administrative action which is contrary to law, if something has to be redone. It's unfortunate, but effectively, whose fault is that? The second thing is it's done in a very offhand way. It's done, first of all, there's a computation of a figure, which I noticed from this morning's newspaper, is less than the money which was poured into the Zambezi waterfront abortive scheme. Thirdly, it's not measured against anything. It's not said it's unaffordable. So how is the court to adjudge the fact that that is a lot of money? How long is a piece of string? But the real point is, as in Rally for Democracy, if that's what it takes, then that's what it takes. Each one of us has seen the plaque outside the High Court in Windhoek, which quotes, put in there in more different times judicially, 1961 or 62, which says in Latin, fiat justitia ruat caelum, let justice be done, though the heaven falls. Now, that has always been the principle, that the first thing one seeks to do is to do the justice. You do have a tempering power, but we're going to argue to you that in fact, although there's an attempt to make your flesh creep that would cost money, and although there is a new thing in the heads of argument for our learned friend, which refers to our friends, which refers to a prospect of chaos, nothing on the paper suggesting chaos. And the Indian Supreme Court, Indian Supreme Court has been faced with this often. Indian elections are fraught events because of the tragic partition that happened in India and all its consequences over 60 years. But the Kenyan Supreme Court, in its judgment which we've given you, refers there to the fact that in the previous election, 1,000 people had died. It was a very live prospect that in the fighting and conflict that had taken place in Kenya, to have another election raised risks. And the court saw its duty that the election had to be rerun, and it made that order. We say the submission regarding chaos shouldn't be made. There is an evidential basis for it should have been made out, but as a matter of notoriety, it's a matter to be deeply thankful for, that the people of Namibia have managed to conduct elections in a way which, from my own observation, is a model to other parts of the region and the world as regards equability and control. So it comes down then to saying it's a lot of money. So we need to step back and say two questions. If you are not with us on that simple fundamental point that the minister did not have the power to leave out the conditions when he implemented Section 97. If you're not with us, then we are out of court. That is the foundation of our argument. If you are with us, we submit to you, then what remains is a consideration of, would you refuse us the relief which ordinarily arises, the default position, Ferreira versus Levine, all those cases that from unconstitutionality comes nullity, unless the court tempers it in South Africa under Section 172 of the Constitution, here under Section 25, Article 25 of the Constitution, and Cran is the example. So those we submit are the two crucial issues in the case, and so much else really doesn't matter. Now, may I then, with the court's leave, start to move into how I need to develop that argument. Now, sorry. Yeah.
Chief Justice Lowe. The criminal example we gave us very earlier seems to me, given the importance of this, when we look at Section 1 of the Constitution of Namibia,
Yes.
in relation to the democratic principles,
Yes.
which are clearly indicated in this letter, legality principles, and also the fact that the right to vote, given also the historical context that you have alluded to,
Yes.
this is extremely important.
Yes.
So I thought that the criminal example that you gave us might be undermining to some extent
No.
But be that as it may, you also mentioned that in the sequence of the remedies, the key issue to Section 97, and the second issue, which is the meaning of the nature.
Yes.
You mentioned the declaration of relief and seek.
Yes.
But if I understood you correctly, you seem to be relating to the nullification of the election.
Yes.
My understanding of this papers is that the real issue relates to the constitutionality of the conduct of the minister in selectively promulgating Section 97. And if that is correct, if my understanding is correct, we have first to determine
Yes.
the appropriateness of the declarative, the applicant seeking paragraphs 1,
Yes.
2,
Yes.
and the setting aside thereof,
Yes.
if we are with them.
Yes.
So I thought that we have to be carefully not to jump the ground and look at the sequential relief sought.
Yes.
If appropriate, we might remind depending on how we deal with the first declaration relief relating to the constitutional issue of the conduct of the minister. If we are with you, then we then have to look at the effectiveness of the relief.
Yes.
And that might take us to the declaration C in relation to 4 and 5.
Yes. Yes. Justice Nkabinde's questions go to the heart of an important issue of how our relief is stacked up and follows. And I'm going to deal with that in a moment, because the other side, as you know, slices salami. It says this prayer, they can't quarrel with prayer 4, which asks that the outcome be set aside, and that is squarely on any approach within the ambit of Section 172. But they say the prayers which precede it aren't. I want to show you it's one set of relief, a suite of relief, and it's just like we often do in cases, which is you seek, first of all, a declaration of status, that something is or isn't void or whatever, and then you follow it by saying, I want a consequential interdict, or you may even on a belt and braces basis seek the review and setting aside of that which has been declared to be invalid. So I want to show, and Justice Nkabinde's question takes us to what is the heart of the relief and how do the prayers interact. But more shortly, Justice Nkabinde is with respect correct that the core of it is the Section 97 problem. If the minister was entitled to bisect the baby, to implement the sub-provisions, then that is an end to our case. If the minister couldn't bisect the baby, then one looks at the relief you would give, first of all regarding what he did, but also consequentially. Because as you know, the Commission says it follows, it stands in the shadow of, etc., of the minister. So if the minister goes, as it were, the legality of that goes, then what it invokes as being able to stand on goes, because there was not a valid bisecting of the baby. I hope that that clarifies.
Thank you very much. I think tied to this aspect, I thought that you were going to give in your own way. I thought you were also going to deal with the jurisdictional aspect.
Oh, yes. Yes.
Because
Yes.
in my understanding, I think this very issue
Yes.
is tied up to jurisdiction.
Absolutely. And that's the next thing I intend to deal with.
Yes.
Yes.
And then also, if you can also address the agency,
Yes.
which Mr.
Yes.
Murray is
know Justice Smuts also has a question. May I just, with the Chief Justice's leave, just quickly say, we shall do that, and we shall do that within minutes, I trust. May I just say, as regards what Justice Nkabinde said about testing the argument, by my argument is if there's a provision that you can arrest a man, sub-provision 1, sub 2, this is subject to the fact that you've got a reasonable grounds, etc. The reason why I give that by way of analogy is that that too involves a fundamental right. This involves a fundamental right. And the question always would simply be, could it be a sensible interpretation of a provision, if there were a provision in the Criminal Procedure Act, that you can introduce, the minister can introduce provisions, that what he could do is introduce sub-provisions, unless, and we've been quite interested by thinking in our minds the test for severability. I don't want to confuse matters entirely, but the court, for instance, would not be able to sever a provision unless it met the Chesterfield House and prefabricated housing test of being satisfied that what is being left represents what Parliament would want, and that what is being left effectively does what Parliament wants. I paraphrase it badly, but the court knows the test on severance. What you can't do, even there, is pick and choose. Even the judge can't pick and choose. The judge has got to ask the question, yes, well, maybe I could chop out that bit, but let's look at this. Now, what's left? Is this what Parliament wanted when it said, 97, you can have electronic voting? We say no. Parliament said you can have electronic voting if. I'm sorry, I know Justice Smuts had what wished to intervene.
Question which I would possibly inquire about is getting chaos. What about the issue your argument that tonight the operation what about the fact that Parliament said the last 5 years of the last laws?
Yes.
I'd like you to that one.
Yes. Yes.
Yes. How would I get these days of the
May I say that Justice Smuts' question and that by Justice Nkabinde really, in our minds, come together when we say that there are two questions, and the questions are, was it, as it were, unconstitutional? And the second is, what are the consequences to be given by the court, if you like? It is quite right that our learned friends say, not so fast. They say they've got these defenses. Point about jurisdiction, which is raised. They say that we should be in the High Court for some things, we should be here for some things, you should remit, etc. They say also urgency, although as Justice Nkabinde notes, it's got a little bit faint. And the short answer is, again, if we're inside 172, we had no choice, the court had no choice. We were set on a railway line determined by Parliament of a very rigorous timetable, which is why we have ruined each other's Christmases and New Year to be here. So the urgency aspect, we're going to say, falls away. And so a number of other issues which we should deal with, the question of delay. This law has been there since 2014. Why didn't Dr. Itula, Mr. Mudge or somebody else attack it before? Should deal with that. But if you like, then, the two main inquiries have a third one, which our learned friends put up, where they say, as it were, not so fast. We shouldn't be in court, or you should send us packing on one or more of those other grounds, and they need to be dealt with respect. The judges are right, and there will be. But may I start to try to get to grips with exactly with what Justice Nkabinde and Justice Smuts are raising by saying, let's look at Section 172. Now, Justices, I'm not sure if all members of the court in all the torrent of paper have neatly available to you, and we've printed it off, the sections in the Act which matter. If not, we have copies which we can make available. I don't know if it would assist members of the court. Thank you, Chief Justice. Now, maybe what I should do is, before I get to 172, because we've started to deal with this, let's look at 97, if we may. Now, 97 is what we would call a lex specialis, a special provision dealing with a particular topic, voting machines in election. This then represents the legislative enactment as made by Parliament, signed by the President, and deposited as the Act in the terms which follow. Now, we want to pick up, after the detail of 1 and 2, which you would have read, that 3. This is where I say you can't chop it off, because it says the use of voting machines referred to in sub 2 is subject to the simultaneous utilization of a verifiable paper trail for every vote cast by a voter, and any vote cast is verified by account of the paper trail. Now, those last words are very important, because unfortunately the Commission relies very heavily on the legal opinion of an engineer, Mr. Rao. Yes, yes, and we will listen to him and look to him with interest, subject to the constraint that the court knows on Coopers and Library, and always the court will decide who to go with or what to go with. But he offers the view, as you know, that the machines he's defending, and defending them he must, because he's an employee of the supplier. And we raise an issue, again, for the caution of the court regarding his independence. But his answer is that paper trails are there for the comfort of the voters. And I go back to what we talked about when you seal vote. And our answer is yes, but not just that. And here we refer to the end of the last words in 97.3, which says that effectively, if there's a dispute, you verify the vote by account of the paper trail. And then if you look at 4, even more strongly, that if they don't agree, the paper trail results are accepted as the election outcome. And we ask the rhetorical question, how could the minister, confronted with an integrated provision, not subsection 1 dealing with cattle, subsection 2 dealing with sheep, subsection 3 with ducks, and subsection 4 with chickens, but dealing with one topic, voting machines in elections, and where in 3 it says the use of the machines in 2 is subject to having this. So, with respect, it was a superficially clever approach, urged on the minister, as we shall show, by the Commission. Unfortunately, there's a... Yes, let me show you that. I think it's at 198. No, that's right. No, with respect, Justice Smuts is correct to correct me. It was not, I can't say that in 2014 the Commission did. What happened in the beginning of last year, the issue was up, as you know, for reconsideration. In fact, 5 of the 11 presidential candidates said, please, could we have 3 and 4? And the submission was made by the Commission to the Minister that these provisions haven't been enacted, so we can run it without the paper trail. So it's an interesting question Justice Smuts asked, because we would think the correct construct is this. The Minister took his decision on this record at a time we don't exactly know, but soon after the enactment of the Act. The issue, however, was contentious. In 2015, as you know, and again in 2016, it was being mooted by the Commission or its chairperson. There's a rather, with respect, feeble attempt to say that when the chairperson was addressing the staff of the commission at the commission, she wasn't speaking for the commission. But crucial thing, there was an indication that we are reconsidering this and that we are in fact positively intending that future elections will be held with a paper trail. The minister effectively, and this is I think my answer then to Justice Smuts, is here deciding in February 2019, should I, as I'm being asked, should I implement sub 3 and 4? And the response, his answer, will show in his affidavit, is based, he says in his affidavit, on the 2014 affidavit of Mr. Rao, son of Srinigar V, and secondly, it's based on the fact that he'd got a memorandum. Perhaps we can find that in the minister's affidavit. Yes, here we are. It's at 194, paragraphs 18. 17, he said he referred to the letter, which he considered, and 18, he said he again reread the affidavit in 2014. So, there we are. Now, I was taking us through 97, so I've made the point about, we say that it was not open for the minister to use section 209 to do that. Chief Justice, may I make a point to which I shall revert, and I apologize if it's out of sequence, but it's useful to make it now. One of the things which we are hit with is one of the points to which Justice Smuts and Justice Nkabinde alluded to these other points, is that, as we understand it, there's a binding judgment called Maletsky by an acting judge in the High Court. Secondly, anyway, the point seems to be muddled as to whether it's suggested that a High Court judge can write a judgment binding on you. The second point is that it's raised judicata as regards my clients. Well, when I get there, I'll give what we think are the two obvious answers. Number one, you're not bound by that. Number two, as regards my clients were not parties to Maletsky, so they are not bound by it. And number three, Maletsky asked for the striking down of section 209, not what we do. We here try to enforce 209. We say if you use 209, you take the bag, you implement the provision. You don't sit there deciding which bits of it you like. So that, with respect, is the answer that we'll give to that. Now, then comes section 115, and may I deal with that briefly? We would ask you simply to write against it, Rally for Democracy, which we don't take. Our learned friends only refer to Rally once, and I think it's footnote 13 of their heads of argument, and quarrel with none of it. Rally for Democracy in paragraphs 142 and 143 dealt with the then provision in similar terms, section 91 of the previous act, and made 2 points which are important to our case. You can attack elections in Namibia on effectively one of two bases. One is that you can show that there are a number of irregularities which are on such a scale, and such a materiality as could affect the outcome. The other is that you can show that an election is not conducted in accordance with the principles in Part 5. And the important point of section 115, as held also in the previous form in Rally, is that to the extent that any onus arises, and we don't believe that it's necessary to go there, but when there is a challenge on one or other basis, it is for the electoral agency to show that, yes, it's put this way in Rally, that once it's shown that a non-compliance with the provisions occurred, the onus lies on the respondent to prove that both conditions mentioned in the curative section have been satisfied, i.e., that the irregularities did not influence the outcome of the election because they were scattered and isolated, etc. And that the attack based on non-compliance with the principles is not such as would affect the election. And I have to make this distinction very clear, because what is said about us here is that my clients come to court with facts in their founding papers dealing with 16 polling stations. It is said that there were 4,000 in Namibia. How can we hope? In fact, it is said we are frivolous, we are vexatious. Unfortunately, the independent electoral agency is not short of pejorative adjectives for those who must still run before it as candidates now and in the future. But they say fundamentally that the application is nuts, because how can 16 pertain to 4,000 odd? They miss the point. Number one, once irregularities are alleged by a petitioner in the old language, under Section 115 and supported by Raleigh, the onus is on the electoral agency, respondents, to show that 115, that the election was conducted, as it were, properly. And I wish to make it very clear, as I think we did in our papers and our heads, but let me try to make it crystal clear. In the time available to my clients, and with the resources available to them, they could not trawl through 4,000 constituencies. They took glaring examples which they said from the outset were symptomatic of what was going on, and which evinced the fact that our attack on the lack of a paper trail is not some sort of smart point that hangs in the air. That there's a real visceral fear among people in Namibia that because they couldn't stand in the polling booth, couldn't see their own vote recorded, and if they wanted to challenge an outcome, they couldn't say to the polling officer, we say this is a dud machine, it's been beeping all day. And one of the annexures by Mr. Rao says one of the reasons why it beep is because it's malfunctioning. And then he must shut it and he must call in the manufacturer, supplier, or engineer. Couldn't do that. So the critical thing is going to be then that our irregularities were put in for that purpose. To illustrate, to be symptomatic, we are not here to win this case by counting individual beeps of individual machines to be met by the answer, yes, but you don't say that in 3,840 machines there were no beeps. That is, with respect, would be to misunderstand the case. Our case is a case brought on the principal leg. Chief Justice, it was both my privilege and misfortune to argue the 2002, 2008, and 2018 election cases in Zimbabwe, where you would know from judicial knowledge and be unsurprised that we came second. The attacks there related to irregularities in certain instances, but the attacks were on the principal leg that I want to illustrate it. If in the week before an election, a government suspends the capacity of the media to function, we have no doubt that this court would say on the principal leg that that election cannot stand. It would require intervention by the court, setting aside, and we respectfully submit the relief we're asking for. In Harare, the newsroom of the Daily Express was blown up by a bomb which had security force provenance. That was a particular misadventure. Security forces were used at times for purposes of electioneering and supporting candidates. These were the kind of things which, at the level of principle, we said that if you can show that that is going on, then on the principle leg, the election cannot stand. So we want to be crystal clear about that, and it's one of the reasons our learned friends say we run away from the irregularities. We don't. We say in our replying affidavit, look what comes out. It's a cogent, compelling picture of symptomatic problems. But we're not asking you to count machines and beeps. And you don't have to resolve that issue if we're correct in our main argument. May I go to section 172, which takes me to the heart of Justice Nkabunga's question. It says that in the election of the president, any challenge relating to the return or outcome, including any request to review. May I just pause to say we don't have a request to review. We don't have the luxury of first asking to review. And the logic of our case is that you can't properly review the electoral results because you don't have what you should have had. So we can forget about that aspect. It's not part of the things. But then it carries on. In any challenge relating to the return of the outcome. Could we just pause there? Our learned friends invite the court to adopt what they call literal and dictionary meaning of the words. We actually would have no quarrel with the application of such a test, other than it's not the test which you have laid down in a number of judgments is the right thing to do in the modern time. Your interpretation of their contextual purposes and the like. But you would, of course, have regard to the words used, and we invite you to. And the words we ask you to dwell on which our learned friends are conspicuously silent, are the words of extension. It's any election of the president, more importantly, any, and then this is the important thing now, any challenge, and then relating to the return or outcome of the election. Now, could we take those bit by bit? Any is any. A challenge is an interesting word to use in a law. They could have said any application for a declaratory order, any interdict, any review, have gone to a specified remedy and cut it off there. But Parliament didn't. It just said challenge. And it did that clearly, deliberately, to encompass within the challenge whether what you are saying is that I challenge the fact that on the return, the outcome, and I think here for purposes I'll come to it in a moment, they're the same, that X has been declared the president of the country. That is what it is concerned with. And the purpose of this section is to ensure that if something as important and fundamental happens as a challenge to the legitimacy of the person who is simultaneously head of the executive and head of state happens, that it comes directly to this court, which this court doesn't like. Top courts don't like it because there's not this filtering out which the court prefers, etc. But none of us have a choice about it. And the reason why it's like that is, might I ask Chief Justice that there is somebody who could possibly deal with the backflow of noise which comes through. I'm sorry for the passage. Thank you very much. It's slightly competitive. It's worse than beeping. The crucial thing is that it's a fundamental thing. It's potentially a constitutional crisis if it's not resolved in the way that it should be. And you can't have for that a plod up through the courts. So for that reason it was said if it's any challenge to the president, the other side in a way says any challenge can't be any challenge. How could it be any challenge? But a ridiculous challenge. If it is a challenge to the election of the president, with respect, it has to be dealt with by this court. If it is ridiculous, as it's put, this court will give it short shrift one way or the other. It might be a 5-minute argument, but the principle is, as in South Africa, if something relates to the office of the president, as in the EFF and Kandla litigation, it has to go to the Constitutional Court direct, because of what the court, that court is being asked to do. And that is all there is about it. But it can't dilute the word challenge. And I'm going to, in answer to Justice Nkabinde, wish to show that what we did in the notice of motion is to ask for a series of incremental prayers. And through prayer 1, it deals with rats and mice about case management, really. 2 and 3 deal with antecedent steps to 4. We could just have asked for 4, which is the setting aside of the election. We might then have been met by an answering affidavit by saying, but you don't say anything about what the minister did, and you're attacking what the minister did, and you should have that declared, and we then would do what? Amend our notice of motion, and in reply, by way of replication effectively asked for that. That would be a messy and dangerous way to go. So we didn't. We played open cards. We said from the beginning, we are a challenge to the outcome of this election. There are component parts of the relief. If they are integrated component parts of the relief, it is with respect specious to say first we must spend a year, 2 years getting prayers 2 and 3 in the High Court, and then come for 4. I'm sorry, just absolutely. Yes. With respect, yes, the rest is subsidiary, ancillary, call it what you will. Perhaps we were being pedantic. Well, we've learned to try to be pedantic. Yes. Absolutely. Yes. 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 Yes.
In the notes of motion.
Yes.
I do understand the point that somehow you also speak prayerful, flowing rather than saying from the very same clarity. But I think it's important for us to believe what the applicant says that the key, the gravamen of the statement relates to what we say in the following case about the key issue.
Absolutely.
So for me, it will also be helpful when one determines the competence of this court to entertain this matter in relation to the conduct of the minister that is impugned.
Yes.
Hence, the
Yes. 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 Now, I shall go there. May I say in that regard that it has been the law, at least since 1950, in Rex versus Abdurrahman, which is that wonderful judgment of the Appellate Division of South Africa, where Mr. Abdurrahman was prosecuted for being a person of color in the wrong part of a train. And when he was being prosecuted, it was rather like the Englishman on the train at Brighton, Boddington. But Mr. Abdurrahman wasn't smoking, as a man might do in England. He was just trying to be a human being and sit where he wanted. He was prosecuted, and he raised as his defense the fact that invalid steps had happened in the gazetting of this notice saying so-called non-whites couldn't sit here. And the smart answer being given was, oh no, you haven't set it aside, the sort of Electoral, pre-Electoral position. You haven't set it aside. You're stuck with this. Did you or did you not sit in carriage number 4? And the law was this. And it was accepted, as it must be, that Mr. Abdurrahman was able to say, but that is invalid because the minister could not have made lawfully a provision which discriminated so grossly between people. And in that instance, there were instances in which, as you know, people failed, but in that instance, it succeeded. So we say the situation here is this. Our attack is squarely and unequivocally that which is, in the end, given expression to through prayer for. We say the election outcome, result, are not congruent with law. Why are they not congruent with law? Because there was no paper trail, admitted. There was no paper trail when in law there should have been a paper trail. We say there should have been a paper trail because 97 is not capable of being bisected. To the extent that's necessary, we ask for a declaration that the bisecting by the minister is declared invalid. May I say that squarely, Justice Nkabinde, I would have no apology for standing up before this court and simply asking for prayer for and saying, this is my reasoning, this is how I get there, and if they want to rely on the bisecting of the baby, our answer will be, but that can't be. Like Mr. Abdurrahman, I can raise it as a shield and say, that can't be compliant with law. Yes. Absolutely. Absolutely. And now what they're trying to say is 2 and 3 can't belong here. May I say that other answer, which, and it's picked up in a way by something Justice Smuts said earlier, those are preparatory to form. They are ancillary to form. And we would make the submission that if this court is dealing with, in this wide language, a constitutional challenge, you will deal with everything which is necessary or incidental to that challenge. And if you needed any authority for that, you would find it in your inherent jurisdiction. But they're never going to find a laundry list. For example, 172 says nothing about you dealing with costs or some kind of discovery order or something like that. Why? Because it's obvious. If you're dealing with a constitutional challenge, you will have the power that goes with it. So, then if I may just finish on 172, if you look at 172.2, that's the answer to urgency. If we're in it, it's urgent. If we're not in it, then we're not in it anyway, we're in the street. Section 209 I want to take attention to last. It's the last of these provisions on the list. And that is the reliance placed by the minister was on 209.2 and by our learned friends. Different dates may be determined under subsection 1 in respect of different provisions of this Act. You've heard my submission, but let me just restate it for clarity. You'd have to interpret provisions in a way which was purposive, sensible, workable. It must ask the question, what would you characterize as a provision? If there is a section which deals separately with sheep, goats, cattle, ducks, chickens, there could be an argument that a sub-provision of that is a provision for the purposes of 209.2. It's not the natural language, because we say a provision would really mean the integral thing. But if your characterization is that it is an integrated provision, livestock, then the minister has to face a choice. The minister either puts it into operation or he doesn't put it into operation. The third point is if there's conditionality in there, then the minister must respect the conditionality that Parliament set. He can't drop it. Just again as in my arrest example, you can't say, well, I like the power to arrest, I'll put that into operation. This thing about the reasonable opinion of the policeman, well, I'm not so sure. Let's leave that. He couldn't do that. So we respectfully submit that that is really the heart of the matter there. May I then, picking up on the questions from Justice Nkabinde, just go then to the notice of motion to explain exactly what we did to answer that, I hope, finally. It's obviously in the record starting at page 1, page 2. I needn't deal with prayer 1. We ask you to condone our grammatical fault in prayer 2, where we should have said were in line 2. If it comes to making an order, if the court would rectify our Christmas grammar. So declaring that the determining by the minister were to be brought into force with the exception of that is inconsistent with, and accordingly contrary to law and constitution. I'm sorry, page 3, yes, the notice of motion. I'm sorry, Justice Langer. So the point we make is that prayer 2 says, right, we are headed for prayer 4. What is an antecedent thing which it may be prudent for us to have separately declared invalid? And we identify the bringing of 97-304 into force. And then 3, consequentially, again, it does the normal thing if you declare something and you set it aside. So it's really 2 and 3 go together. And then 4, setting aside the adoption of the Electoral Commission of Namibia of voting by way of voting machines in the 2019 presidential election. Again, it goes to an interesting point that Justice Smuts raised, where I qualified an earlier answer I'd given. It's evident that the Electoral Commission, we say, we don't know because they haven't told us, but consequential upon that letter it paid that 199 saying to the minister, look, you're being asked to implement now 97.3 and 4. You don't have to, effectively 97.1 and 2 are in there, 3 and 4 haven't been implemented. You'll notice there seems to be no sign of external legal advice, no consideration at all of the argument we've addressed to you that you can't bisect the baby. So unfortunately it seems to have been done without advice on both sides. And then comes the key prayer, setting aside the adoption by the Electoral Commission of Namibia of voting. Our learned friends call that our secondary relief. They call the other our primary. It's not so. This whole case was to say the wrong person has been declared to be president because there has been non-compliance with principles of Chapter 5, requiring, we say, the election to be rerun. And the rest is clearly the scene setting and getting there. Now, may I pick up, though, on the further points which are made regarding jurisdiction. Although the various further other points, to the extent I haven't covered them. We ask you, on a simplified basis, to note the following common cause, and our learned friends will tell us where we are wrong, but factual scenario. 2004, the Act is made and is gazetted as regards 97 as to half. That's right, 2014, yes. 2015 already, there is the indication that it is accepted that to proceed with a paper trail in future elections is the way to go. The right thing to do. Yes. And this is going to start coming towards Justice Nkabinde's questions and Justice Smuts regarding the issue of delay and the like. 2016, there is a similar statement in the opening of the premises of the commission. There's a little bit of denial about that, but a rather implausible denial, given the fact that it was never corrected. It was published in the Namibian. You would have thought the first thing that would have happened in a statement like that, under a headline, would be some repudiation. Never done. And an affidavit is put in by the journalist concerned saying she's checked her notes. The chair did say that. Be that as it may, there is the February 2019 letter, which then goes to the at page 198. And this is an aspect again, document, it's their document. We ask you to look closely at this and to note it. We don't quarrel with it, we rely on it. This is the Commission effectively advising the Minister as to what he should do about the request about implementing 97.3 and 4 for the purposes of this last election. We say that it establishes that clearly this was a matter for consideration and that the minister decided against changing his previous stance. No, it's PM1 on page 198. And you will see in line 4, it's called a comprehensive response. It wasn't dashed off, it was thought through. The second paragraph is critical. It's that the Commission unequivocally agrees that a paper trail will increase voters' trust and confidence and further enhance the credibility of our electoral system. This is important because it's not as if there is some substantive argument. Anybody in this court says there is a reason why it would not be, as the Chief Justice recalls the words, a good thing. Then it gives the two functions, please note at the foot of 198 of the paper trail. One is that you can instantly verify, and secondly, it's a means to store to audit the stored electronic results. Mr. Rao is wrong, this letter is right. It's not just one function. Over the page is the page we've read, the paragraph we've read. Then comes the right thing to do. It's ideal and desirable. The problem with that paragraph is what the Commission wasn't grappling with was a narrow question, and that is, as it should do as an independent body under 94B and charged independently ensuring compliance with the Constitution, it should have gone beyond what's a nice thing to do, what's a good thing to do. It should have been saying, well, taking some legal advice as to whether or not you could bisect the baby. Then there's the sacred legal obligation, and then you get the story beginning about India in 199. It's very simple. Namibia bought these machines in India from Bharat & Company. They are the supplier manufacturer. On the paper, the only other countries in the world which have seen fit to buy the machines are the two rather diminutive mountain kingdoms in the immediate armpit of India, Bhutan and Nepal. Namibia buys them. The Indian Supreme Court in 2012 or 13 says no, there's a real problem. You can have these machines, but you must have a paper trail. So what's happened in India, and it's all there in Mr. Rao's affidavit, not always very clearly, but what comes out is that, and in this letter you'll see, they're now too busy, frantically busy, trying to, Bharat, get the machines adapted in India so as to run an election compliant with the Indian Supreme Court's requirement of a paper trail. So when Namibia said, please help us, can you, because we think it's the best thing to do, it's a good idea, can you give us a paper trail? The answer came from our supplier, the supplier. We can't do it this year. Now that left two choices which are then, or a choice to be grammatically correct in this letter. The choice was this. The choice was to find another supplier. And this letter, and references in the papers which we can give you, say yes, there are other suppliers, and one, and in particular India, which the Indian electoral authorities think is fine, gives you a 95% verification rate. For some reason which is not explained. I wish, Chief Justice, I could win 95% of my cases. But, or doctors, or my client would wish that 95% of his procedures were successful. It seems to me extraordinary that without further explanation, this alternative source was rejected because it produced a 5% failure rate. If that source had been turned to and used, this case would be very different if it had been brought. Because the argument then might have been on my side, look at this, a 5% failure rate. I suspect the court would say to me, Mr. Gauntlet, this is the real world. These machines have a 95% success rate. We would think in the real world, that is a compliant paper trail. Perfection can't be the enemy of the good. So it didn't happen. They turned away, as this letter shows, from that alternative source. And they did another thing. They advised the minister here, let's not have a manual ballot. Let's not vote as they do in Botswana, South Africa, Lesotho, Eswatini, elsewhere. And they make some good points. We know that manual votes are, as they say, tedious. We know that there are problems about security of ballot boxes, just as we've seen here, there's problems about security of machines. We know all of these things. But that was the default option. And instead what they did, and this letter ends up saying, is, Minister, you're lucky, we're fine, we've got a get out of jail card. And our get out of jail card is that you did not then gazette 97, 3 and 4, and effectively, implicitly, you don't have to gazette it. So we're covered as long as only 97, 1 and 2 are in operation. And we submit that that's what makes this case ultimately simple. Was that compliant with the law? And it involves, and it goes really to Justice Nkabinde's probing of the relief. You've got this cumulative conduct. You've got the minister doing his first thing in 2014, which is, as we put it, to bisect the baby. You get the provision, but not the protection. You get the statements which come afterwards by the Commission saying, you know, the way to go is a paper trail. We support that. It's best and ideal. You get other candidates saying, please, Minister, in good time for the last election, please, could this happen? And the answer is no, because the supplier can't give it to us. That's the real answer. And the other supplier we reject. And thirdly, we don't think we want to go back to that. So that is why it's important to disaggregate, although the crucial thing is the minister's original determination in 2014, is to disaggregate these other steps. And that's why we've done so in relation to the relief. But it's also for another reason. How did we delay? Well, it is suggested that my client and my clients have had from 2014 to 2019 to attack this provision. First of all, there seems to be this misunderstanding that they were litigants in Maletsky. They weren't, and I'll come to that separately. Secondly, my client is a first-time, I'm just going to refer to Dr. Itula's position, but is a first-time presidential candidate. It is the first time that this issue has crossed his door. Without delay, from February, there's an attempt to rectify it. There is the fact that only on the 25th of October, 5 weeks before polling day, does the answer come. No, there's not going to be any polling trail. Within a week, he challenges it, he and his colleagues. They're challenging it through the Electoral Tribunal and the High Court. They fail there, and
On that point, why doesn't he go to the High Court?
Because he did, and because there is now an outcome. And once there is an outcome, then the outcome would have to be challenged. And the only court that can entertain the outcome challenge is this one. It's a very important question, Justice Mayunga asks, because
They left, say suppose they might people have voted in that. Why couldn't at the time, on the 25th of October, why couldn't you have gone to the High Court?
But he did. Oh, we went to the tribunal. Oh, I see, yes.
Straight to the High Court and seeking urgently to stop the whole of the election of Mr. Access. You agree that there was a regulation to the
But if we look at what they've tried to do before the tribunal, that's in effect what they were trying to do. So they in fact went a step down. They went to the tribunal They were asking the tribunal, raising this issue, and saying that the tribunal don't allow it. You would either have been impressed or not impressed by the reasoning of the tribunal. We would suggest the latter, but the important things are not here on appeal from that. He then takes that from the tribunal to the full court. The full court is this curious thing, which is to decide, and with great respect, find it very difficult in the context of an election case. There was this fastidious concern for what was on e-justice and what wasn't on e-justice, and it's...
One problem is at the time, the 25th of October, there is that the ECN is still going to use the EVM without paper.
Yes.
And that is his case here.
Yes. Yes.
Why doesn't he afford to buy this one?
If he had If he had approached, as you put it, the High Court, he would have been confronted with the answer. Electoral matters have a special electoral election hierarchy. You can't just wander into the High Court. You have to go to the tribunal, and if you don't like the answer you get in the tribunal regarding the conduct of the election,
the tribunal cannot decide over a constitutional matter.
well, Justice Maingo, would you look at page 88? 88, yes. Those were the orders asked for, paragraph 3, before the tribunal. This is a question of being sent from pillar to post. This is what he asked for. That EVMs must not be used, i.e. an interview, in the upcoming elections. And the comment is, this seems to be a challenge against the Commission decision to conduct election by way of EVMs taken by a period. He goes to the correct forum to ask for, rather roughly put, that the correct remedy, it gets refused. If there's a thought, Justice Mainga, that he should parallel with the prescribed electoral mechanisms, i.e. the tribunal and the appellate body above the tribunal have gone sideways into the High Court, we respectfully submit that that would be contrary to law. He would rightly be thrown out by a duty judge in the High Court by saying, excuse me, is this about the election? Yes, it is. Are you asking me for an order relating to the use of machines in the election? Yes, I am. Why are you here? Is there not an electoral tribunal? So, with respect, he was in the right place.
That would be, we don't know this speculation.
I beg your pardon, Lord?
We don't know, that would be speculation. Whether the High Court or the Electoral Court would have sent him away.
No, I'm suggesting, Justice Mainga, that is the likely outcome. With respect, it's not speculation. It's analyzing the position that there is a hierarchy, and the hierarchy, we say, is this. There's a special mechanism for dealing with a challenge on the outcome. Prior to the outcome, if you have difficulties, complaints with the conduct of the election, you can't go to other courts. You must go to the specialist tribunal. If you fail there, you must go up from the specialist tribunal to its appellate body, and that you would not be permitted to go sideways. May we say this, that we respectfully submit that that is the correct answer, and that then the position is that what he does is, having done that and having failed, outcome happens. On the basis, he said, it really shouldn't be done this way. And he challenges it. Either that is a challenge, or it is not a challenge. We would respectfully submit that if it had been that he could have gone to the High Court in November as opposed to come to this court in December for the outcome. What is being said to him, if it were correct that he could go to the High Court? That he delayed fatally? In doing so, we respectfully submit not. That he didn't exhaust remedies, which I think is probably what Justice Malinga is suggesting, but where is the remedy spelled out? That what he could do is go to the High Court. We submit the remedy which is spelled out as the different one which he excused. So we submit that there is no credible basis on which one could say to him that his presidential challenge must fail. Because as between getting the letter in October, somewhere between the tribunal, the Court of Appeal there, and here, there was some other means permitted by law, prescribed by law, which he failed to exercise. So I was in the letter and saying how crucial it is. And then in the letter, at pages 200, the court would see in paragraph 3 is what I've already drawn your attention to, which is the rejection of the 95% success rate, which is good enough for India, but rejected by the Electoral Commission of this country without further explanation. Then there's an interesting problem, which they don't rely on in their affidavits, but that they didn't have the regulations lined up. Well, that's a pity. The Commission can be seriously criticized for this. It's been talking since 2015 about running this, the right thing to do. And now it tells the Minister, well, we don't actually have the regulations to do this, and ends with a rhetorical question, would this be acceptable in Namibia? And then comes the main reason which they give, which is they didn't have a supply, having rejected the alternative supply. And then at page 202 to 203 are the concerns with manual voting, which have been lived with for a very long time and are lived with by most countries in the world. Then comes the crucial reason in the middle of 203. In terms of the specific request to invoke 97, we wish to state the following. And then they quote section 209, and then they go on to say that as a result, it hasn't come into effect, therefore they cannot be considered peremptory stipulations. And then it says that it can't be said that the Commission is obliged to use them, and they say this, which is very telling. It is not a condition on the use of voting machines in the middle of that third last paragraph on 303. Parliament said it was, and that's the difficulty. So it really is a remarkable sleight of hand for the Commission to be saying, this is not a condition. Parliament had seen it that way. Parliament had made one provision, and the reasoning becomes, with respect, totally circular. Chief Justice, I am aware of the fact that I am about to exceed the provisionally allotted time, and may I seek... May I ask my lady what page you're on? Thank you. Yes.
In the last paragraph, the last line, the following appears. It's a collective speaking. The use of e-means without a paper trail is a breach of our constitutional rights
Yes.
to freely choose our representatives. Now, given that statement, which to me is telling,
Yes.
I can wonder why was it not important for the applicant to appear based on this consent and other consents that we know that is totally set that the use of the EPS? Why was it not important for the applicant to involve 172 and approach this court? The National Extreme Agency in November, in October, in November, and say, here is the quotation of our right to vote being violated by the conduct, not only the minister, but probably also the commission. Why was this not done at the very least?
Is confined to the outcome or return of the election. You can't use 172 until there is a return or an outcome. And the legislative scheme is that if you want to challenge the election, presidential or otherwise, up to that stage, you've got to use the specialist, as they are termed, bodies, the Electoral Tribunal and its appellate body. 172 is a challenge relating to the return or outcome. And I cannot think of a more short-lived application than one to this court or any other court, which says, pursuant to section 172, well, it would have to be to this court, I'm seeking some kind of interdict to stop that which I say is going to happen. The answer will be that you can't. There's no return or outcome yet. So that's the interesting thing. The scheme of the Act has the mechanisms before you reach the return or outcome. Once there's a return or outcome, in relation to the presidential election, there's only one place to come, and it's here.
I hear you. In relation to the constitutional selective for migration,
yes,
that's not enough.
That is not?
That's not enough.
Yes.
It is the constitutional, as I understand it,
Yeah.
it is the constitutional attack on the conduct of the minister
Yes.
in relation to this legislation, which I think fair places the applicants here to get that relief in paragraph 2, if we are waiting. Now, if that is not the outcome, as you put, why is 172 jurisdictionally correct for us to be here?
I don't know that I follow, my lady, but the point is this, that 172 is the specialist exclusive jurisdiction of this court, and exclusive jurisdiction, and it relates to a challenge only relating to, so it's broadly put, relating to the return or outcome of the election. It can't be triggered in any way until there is a return or outcome. Once there is a return or outcome, if you've got a challenge relating to that, as regards the presidential election, there is only one place to come, and that's here. That's my one answer. My other answer is this. The lady will recall that my client first learned on the 24th of October, got the answer. After all those years going back to 2015 that everybody says paper trail is a good thing, and we're going to do it. We're going to do it for the next elections. He hears, and you saw that internal debate going on in February, that annexure page 199, annexure PM1, between the Commission and the Minister. He hears on the 24th of October, there is no paper trail. And now I go back to the debate I had with Justice Mainga. What the applicants do is that they obey the prescriptions of the electoral law, that if you have a pre-outcome challenge of any kind, you've got to go through the specialist fast bodies, the Electoral Tribunal and its appellate body. You can't go to the High Court, you can't come to this court. So the one is jurisdictional. We couldn't have gone there. The other is it would be utterly unreasonable to expect of a candidate who first learns 5 weeks before polling that what has been indicated over a period of time, as is going to happen because it is so good, to expect him or her in that time, we respectfully submit to do anything else. But the first point is that it's jurisdictional, and secondly, the questions posed by Justice Nkabinde could only go to some suggestion of unreasonable delay or failure to exercise another bespoke statutory remedy. There was no other remedy. He did the right thing. And secondly, he didn't unreasonably delay. He was blindsided.
So let me tell you why I'm worried about that. It comes to mind that it could have been possible, even on an extremely injury very outdated application,
Yes.
to say to your court, look at the concerns of the Congress. The elections are just around the corner.
Yes.
There has been a concern about this
Yes.
event
Yes.
since 2014, continuously. People have been worried about this. And we see an order on an extremely basis. Supreme Court stop the election or postpone it. It was an order postponing the election so that the act can be complied with. Was it not possible?
No. No, let me repeat. It is far-fetched, and then I explain why. There is a particular provision which singles out that to which this court, for very good reason, and the lawmaker, about which should be very careful, as in South Africa, about giving direct access to the Constitutional Court, although there it's a lot more discretion and widely formulated. Here, in the context of electoral law, there is, we submit a clear before and after position. If you have any issue regarding the conduct of the election about to happen, you cannot fall in short. You could not go to the High Court, you couldn't come to this court. To do that would destroy the logic and the symmetry of the Electoral Act, which is, it all goes to the eye of the needle through the Electoral Tribunal. Yes. Thank you. So you would have to go through the Electoral Tribunal and up. Secondly, my lady, the language of 172 is very specific. It is what I call post. It's relating to the election or outcome. And you would be dead in the water if anybody came to this court saying, you know, I think a terrible thing on the probabilities is going to happen. court would say this is an exclusive and careful jurisdiction. Do not pull the cord on the train before you've reached the correct moment. There will be no jurisdiction. And thirdly, that point is underpinned, as I'm reminded, that Article 79(2) that provides the Supreme Court, and this is a provision our learned friends rely on a lot, should deal with such matters referred to it for decision by the Attorney General and with such other matters as may be authorized by Act of Parliament. It's been authorized by Act of Parliament to deal with the outcome. It is not being authorized by Act of Parliament to act as some sort of roving Uber for concerned litigants before the election. And we say that for that reason too, that would have been so. But I still would rhetorically question what is underlying this. Is it a suggestion that you would deny jurisdiction to a presidential election candidate because, having been told publicly up till 21 October, this is going to change, learning then that it isn't changed, in good faith going through these other routes, whether they're always competent or not, I mean, the way it was conducted on, as it were, our side, and getting that result. In the first week of December, days after the outcome, there is this challenge. What is one saying? Been delay? A failure to exercise remedies? We would respectfully submit that that wouldn't be right on either of those pigeonholes, and one's got to put it somewhere. Not just this sort of visceral feeling that couldn't have gone off and done something elsewhere. We submit the short jurisdictional answer is no, and secondly, the conduct was reasonable. So, may I now wrap up, Chief Justice, because I'm short. Thank you, Chief Justice. Chief Justice, what remains are a few other aspects of these other defences. There's been the question of urgency, and I said my urgency is statutory. I'm either inside or I'm out, and if I'm out, then I'm out, so there we go. Delay, there isn't delay. I may be affected now by a statute which is on the statute books. I'm sorry, not affected now, potentially affected. My clients would have had no locker standing in 2014 to have said, we've got a serious complaint in this country. The minister hasn't gazetted half of Section 97. Court would say, well, why is that your beef? You're not candidates. It would have to be done on an extrapolated public interest basis. But the bottom line is it's not the way things work in the world. My clients become candidates, they then challenge. As regards the issue of Maritsky, the following brief points. One is, as I said already, it doesn't bind. That's what the affidavits plead. Secondly, it's not raised judicata because it wasn't the same parties. We've checked against the original report, and you will see what you would know is that the applicants in this matter were not parties. Secondly, in that case, there was this bold attempt to strike down Section 209. There's nothing wrong with Section 209, as was explained in pharmaceutical, for the executive to implement, for good reason, incrementally, as long as it implements provisions, not bits and pieces of provisions. And that's been our case. So it's not the same cause between the same parties at a previous stage. As regards our learned friend's argument, may I just say this, that what is significant is their glancing reference to Rally for Democracy. Rally for Democracy lays the foundation for this case. Rally for Democracy makes the most important holdings, which we've quoted in our heads of argument, about the primacy of the right to vote, about protecting it, about the court's role, etc., and about the court not shrinking from the money consequences. It's dealt with that before, if it has to. its answer to our reference to the compelling persuasive authority in the Odinga judgment of the Kenyan Supreme Court is its one line. They say, because we can't get into section 172, we ask you to apply Odinga. No, we don't. And we know this court is much belabored by counsel like me, who will present comparative law. But there is a compelling rationale there which we invite you to follow, called the due respect to in Odinga as regards two things. One is the primacy or the importance of the check of the paper trail, and two, because it's a matter of legal policy throughout the world, as it is the position in Germany and India, about which again our learned friends have said nothing, because there is nothing to be said. And then may I turn to the issue of relief. We have said that if we are wrong about the bisecting of the baby, we are out of court. If we are right about the bisecting of the baby, and if we are right that the jurisdictional objections raised against us are attempts to raise points of nitpicking form over substance, yes, we would be out of court if we don't come home on the contention that the minister could not in 2014 implement half of 97. We say that's absolutely fundamental to our case. We accept that.
Meaning that if you are not minded to the first examiner in two and setting aside the determination, you are out of court.
I say if you are not minded, if you are minded to find that as a matter of law, the minister was entirely free to choose which portions of the provision constituting 97 to implement, then we're out of court. Oh yes, I'd said that at the outset. Yeah.
It doesn't have to be a direct declarative that
Yes. No, the thing about the absolutely. I will not, however, be pinned to the declarative. We put, to repeat, the antecedent declaratives in 2 and 3 are antecedent to 4. I did say, I thought, specifically, that without embarrassment and difficulty, we would stand before you and have argued simply for 4. But because one is used to the sort of to and fro of legal debate, the other side saying, well, what about this and what about the other, we squarely pleaded, as you raised earlier, pleaded in our finding case and asked for relief to say that these two provisions are invalid. And I again go back to Abdurrahman. It's a very important principle, because if one challenges, for example, the decision of the station commander at Okahania, and he said, well, you haven't challenged the order I got from the commissioner. And then the commissioner says, well, you haven't challenged the standing order this. The argument we would say, depending on the circumstances, which is always the position about Electoral and the like, that we would be entitled to say, in circumstances, that you, the station commander at Okahania, were not entitled to do this to me. So we want to be clear about it. We don't nail our colours to that specific prayer. We say that logically you should grant it. If you didn't want to grant it, you just wanted to give us 4. But the crucial thing we have to do is grasp the nettle. Are we right or wrong about what I call bisecting the baby? Could the minister choose which parts of the section to put in? So if we're right, if we are right about that, then the question is what relief? And just to sum up our argument on that again, to be clear, for reasons of important legal policy, if something is contrary to law, this court, that being a violation, entailing violation of rights, would seek to give its normal corollary, which is, first of all, it would be its duty, we submit, to declare it. But secondly, as regards what's consequential upon it, the court would take account of circumstances but it would proceed, as Cran indicates, from the default position of objective unconstitutionality. That if something is not compliant with the Constitution, the normal position should be that it is not given effect to. It's very important as an indication of the stance of the court, of the primacy of the Constitution, etc. But the court will temper that in circumstances. We submit that in these circumstances, what are you left with? You're left on the papers, let me find it, with the plea to money, the plea about money. And what it does is, first of all, it gives a figure of, I think, $110 or so million. It gives it in respect to the rerunning of both elections. Now, may I just say that also to make your flesh creep, the other side says, well, we don't challenge the national elections. We can't under Section 172. What would happen about them is not with respect for my lords. Not in this matter, my lord and my lady. It's not raised by this case. It'd be a very interesting situation. We trust that the Electoral Commission has made its own pre-thinking and planning for it. But the bottom line of it is the calculation is wrong. Secondly, you're not told what the national budget is for anything, for what's available to it. You know, as one sees out of the corner of one's eye today, that unfortunately sums of money are spent and misspent as we go. And in principle, as was held by the Constitutional Court back in Ntuli, it's not an answer for the executive to give, and this is what Rally for Democracy affirmed. To say, well, it'll cost us a lot of money to fix that. Rally for Democracy, this court said that's not in principle a good answer to do, because if you think about it, what's it all about? If you think back to the fourth paragraph of the preamble, without a functioning democracy through functioning elections, you're saying to people, what we'll give you is some sort of declarative, maybe, that says that wasn't an election, but sit with the consequences for 5 years. You have an effectively unelected then head of state and head of the executive. Legitimacy and credibility are destroyed. We respectfully submit that not in the worst circumstances in Kenya did the court consider that that was the right thing to do. So we respectfully submit that the order we have sought should be that. And Chief Justice, as regards costs, we would ask, we're here to vindicate rights. We are political activists, leaders, who have been obliged to go to these lengths to vindicate their rights. If we are right, and they were done a legal wrong, then we would submit that in that event, the cost should follow the result, and we respectfully submit to the circumstances of this case the unambitious order of 2 instructed and 1 instructing counsel, and we would not include all the sedatives we had had to share in the process. Yes, sorry.
Find that there was, in the circumstances of this case, a delay, but we are not minded to consulting the applicant.
Yes.
Would it be appropriate in that those circumstances, if you choose so far not to run the concert to the applicant, to express the court displeasure? As our party says, that it is undesirable to approach the court and exchange agency when something that is if we found and not we prove that there was no delay. Will you still be entitled to a course that you see?
Yes. We would respectfully submit that if you hold that there is a delay by my client after learning on the 21st of October, or if you embrace the reasoning that my client, while he was still a medical practitioner and not a candidate in this election in 2014, 15, 16, 17, or 18, should have attacked the adoption of 97-304. If you hold one of those two things, then consistent with intellectual honesty, you would have to throw us out of court. If you don't do that, then I would not with respect understand on what basis my clients would be penalized in relation to costs. Because either the delay point is a good point or it's a bad point. We submit that it's a very bad point for the reasons that I've given. My client is not required by law to consider attacking a provision until he's an election candidate. Secondly, he didn't use all remedies. Thirdly, he was being told it would be fixed. Fourthly, he learns at the last moment.
I'm not sure if you concluded your sentence on cost.
No, I didn't. Yeah, thank you very much, Chief Justice. What I was saying on costs is that we had to come here and that cost order should follow as we've asked. If you were to go against us, we would ask essentially for the BioWatch principle that this has been a serious and important case, that we have been here to vindicate rights. And it would be a chilling effect in particular for those who do this, unless you decide that we are in some way frivolous or vexatious or the like. I know submissions have been made in that regard, and we would hope that you would see that this has been a very serious case. But that's the alternative there. But to sum up, if I may end where I start, there are truly only the 2 points. The points are whether you could bisect the baby, and secondly, whether or not we are to be given a gold sticker if we win, which says, yes, you win, but nothing else. We respectfully submit that would not be justice, and that the ordinary consequences of invalidity would follow, and with it the rerun. On that, we may point out that in our notice of motion, we'd rather expect that the other side would have framed an order for you, that if it's against them, what are they suggesting, what time frame, and the like. They haven't done that. It's a matter which may have to receive some consideration, but they would have to proceed, obviously, with all deliberate speed. If you're with us and they're required, as in Kenya or India or Germany, to rerun an election, in Germany I don't have. But, so that's what we would ask for by way of order.
One other matter, I'm not clear when I hear you correctly. The question was asked by the left.
Yes.
The question is, what are the legal consequences of granting namely the legal consequences of sexual attack
on what has happened at the law because in the court is good, there was a balance at the start.
Yes.
What about the proceedings at the last part?
Yes. Yes. We are challenging only this election in this challenge. We would respectfully submit that to the extent the court considered it necessary, it could clarify that there is no wider effect than that we are setting aside this election. And the other side haven't asked for any particular orders regarding anything that might have been done by the President between the declaration of the result, or rather his swearing in, and now. But we would have no objection, Justice Smuts, Chief Justice, to some provision which, of course, was of the sort of saving kind, as in Cran, which clarified that there is that those any such actions are left intact up to and including the finalization of the outcome which you so direct of a new election. So there would be, it would save any hiatus, and it wouldn't reach back into the past. Thank you very much for your patience. Thank you.
Okay, could we take a break now? 10 minutes to review for the bias.
We lose ourselves in the spirit of things. We lose our sight when we put our trust in things of this material world, of things that fade away. Yet we keep coming back, keep coming back, keep coming back, keep coming back.
Van dis ons land, dis ons taal, en sonder soek aan ons gaan stories. Maar we lewe in die tuine
We lose ourselves in the spirit of things. We lose our sight when we put our trust in things of this material world, of things that fade away. Yet we keep coming back, 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 keep coming back. We lose ourselves in the spirit of things. We lose our sight when we put our trust in things of this material world, of things that fade away. Yet we keep coming back, 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 keep coming back. We lose ourselves in the spirit of things. We lose our sight when we put our trust in things of this material world, of things that fade away. Yet we keep coming back, 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 keep coming back. We lose ourselves in the spirit of things. We lose our sight when we put our trust in things of this material world, of things that fade away. Yet we keep coming back, keep coming back, keep coming back, keep coming back.
Want dis ons land.
We lose ourselves in the spirit of things. We lose our sight when we put our trust in things of this material world, of things that fade away. Let me keep coming back, 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 keep coming back. We lose ourselves in the spirit of things. We lose our sight when we put our trust in things of this material world, of things that fade away. Let me keep coming back, 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 keep coming back. We lose ourselves in the spirit of things. We lose our sight when we put our trust in things of this material world, of things that fade away. Let me keep coming back, 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 keep coming back. We lose ourselves in the spirit of things. We lose our sight when we put our trust in things of this material world, of things that fade away. Let me keep coming back, keep coming back, keep coming back, keep coming back.
Want is ons land, dis ons daar. En sonder soek aan ons gaan stories. Maar we lewe in die tuine hoog gebou uit sand. Die helder sien
We lose ourselves in the spirit of things. We lose our sight when we put our trust in things of this material world, of things that fade away. Let me keep coming back, 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 keep coming back.
Chief Justice, I wanted to assist Justice Haringa with two references which may have helped in relation to his earlier question, and it also touches somewhat on Justice Kabinda's questions. It was the issue about going to the High Court. The specific provision which makes it clear that, as I put it colloquially, any beef, any electoral issue you have pre-polling day, we go to one place and one place only, is the electoral court. That is section 162(2) of the Electoral Act, 162, subsection 2. All matters arising before polling day, whether the election or referendum, are adjudicated upon by an electoral tribunal, and all appeals are addressed to the electoral court. Secondly, it is not a question of speculating as to what the High Court would do if you went to it. We have a judgment before you, which I know the friends rely on, will show you, and that is at page 180 of the record. In paragraph 33, the High Court said, I consider this application was launched to be heard late before the elections. The response was granted to this court instead of the electoral court. And he dismissed it on that jurisdictional basis. So, only electoral court before polling day. Afterwards, there's the exclusive and sole jurisdiction as regards presidential elections to this court under 172. That's our submission.
Thank you. Mr. Bakari, then please. Mr. Bakari, as Mr. Gauntlet did, perhaps you may wish to start by setting out your roadmap of your argument.
I am ready, Chief Justice.
Please, thank you.
Thank you. Before I identify the 7 topics that I'd like to make submissions on, I'd like us to locate the applicant's case in its proper place. That we will find it from the submission of Mr. Gauntlet, which he made not once, not twice, but 5 times. Even in circumstances where Justice Smart attempted to get clarity, but in circumstances where Justice Nkabinde, right at the outset, wanted the court to understand what precisely is this case about. Mr. Gauntlet said the following: this case is about the minister's conduct in bisecting Section 97 when promulgating the Act in 2014. Indeed, that is the case that we have been called to this court to answer. And that is the case that we have pleaded to. He repeated it in fact when he said, if the minister was entitled to bisect Section 97, then I will be forced away. That is the case that we have before this court. In fact, he's correct because Mr. Gauntlet fully understands that these are motion proceedings where the cause of action is determined in the pleadings. In paragraph 6 of the founding affidavit, at page 12, and this paragraph is located under the subheading Nature and Purpose of this application. The department says, at the heart of this application lies an important constitutional issue. This is whether the Constitution permits the selective promulgation at the choice of the executive of part of Section 97 of the Act as adopted by the legislature. This is not, it will be shown, what Section 209(2) of the Act authorizes when it provides for the provisions to be introduced at different times. So that's really the case. That is really the case. And this case, it then gets crystallized in the...
Mr. Mukari, please bear with me. Right at the outset, interposing. Shouldn't we read that part together? The following part is up to 8. I do not think it is appropriate to read it in isolation. It's a line of writing to read somewhere. Now, you can't read 6 in isolation. You read the nature and purpose of this act. You see that in both.
Yes. Yes.
That is texture under that heading 5, 6, 7, and 8.
Yes. You're absolutely correct, Mr. Nkabinde.
So I don't think it's appropriate to read it in isolation.
I was going to come.
I think I understand what you are saying, but I think it would be helpful if we get it right from the outset. Precisely what they are saying.
Yes.
And as you say correctly, he addresses the applicant addresses the nature and purpose of the application. It's not only about paragraph 6. You can say paragraph 8.
Yes.
The resource is in declaration that the selective promulgation of parts of Section 97 of the Act is unconstitutional for violating the separation of powers an order directing the ECN to conduct fresh clearing in compliance with the Constitution and the law within a reasonable time prescribed by the government. Now, that summarizes what Mr. Gamble was saying. That's why I'm cautioning with respect that I'll say that let's not read this part of the affidavit in isolation.
Yes, I accept that, Justice Mkabile. In fact, I was going to return to paragraph 7 and 8 because I started at the beginning with what Mr. Gamble has said and to show that it accords with what paragraph 6 said. But I'm still going to come to paragraph 7 and 8. But then let me just deal with paragraph 7 and 8 at once, at this stage. Paragraph 7, it simply flows from paragraph 6 because it still refers to the same bisecting, that is his own construction, because he says, as will be shown, although Parliament enacted Section 97 as a single integrated provision provide a comprising 4 subsections, the relevant member of the executive chose not to promulgate subsection 3 and 4 of the same provision when putting subsection 1 and 2 into operation with the rest of the Act. And then in paragraph 8, then he draws a conclusion that once the court finds in our favor in respect of that conduct of the minister, it follows that the court should then set aside the presidential election and order a rerun. That accords, Justice Mkabile, well with what they say in the heads of arguments. Because what they say in the heads of arguments is that the primary relief that we seek is 2, 3, and 4. Once you get there, then you must upset the elections by setting them aside and order a rerun. So that's what I say.
That can't be correct. The primary relief that is sought while the applicants are in this court is to set aside an election.
No.
The other relief, well, that's how I can just tell you, understand it, because that's why they're here. The other relief is ancillary to it, and that's the consequence of the other relief that they are seeking.
No,
the primary relief is to set aside an election, otherwise they wouldn't be here.
No, that's not what Mr. Gamble has said. In fact, Justice Martin, you have asked him 3 times, and you are very emphatic that the point of departure is that they are taking that conduct of the minister flowing from it. And that's why in the heads of arguments, they are referring to the primary relief and consequential relief.
It's a welcome change, hopefully. Yes, continue.
Continue.
Yeah, you continue, so that you have to raise your voice now. There appears to be some change in the circumstances.
Yes, I'm still answering the question, Justice Martin. So I'm saying that I'm moving from the premise of what the papers are saying and also what the heads of arguments are saying and what has been submitted. The primary relief is the declaratory order, and that's what they say in the terminal day. And they say that once you grant us a declaratory order, you cannot deny us prayer 3, which is the setting aside of that determination. Flowing from that, we will then be entitled to prayer 4 and 5 and 6. So that is the case that they are playing. So the consequential relief, according to what has been pleaded, is a setting aside of the presidential elections. The setting aside of the presidential election, Justice Smart, on the papers, as they stand, and based on what Mr. Barnett has said, is not the setting aside of the elections, but it is a setting aside of the ministerial determination. Hence, Justice Mkabile engaged Mr. Barnett on the points that we have taken. So are you going to deal with the issue of the jurisdiction in respect of that point, electing to a declarator, and I'm going to deal with the point of ethics. So I just wanted to outline the case as it appears on the papers, and then from there deal with the topics that we have set out to demonstrate that the primary relief that we seek, which informs whether the consequential relief can be granted, cannot be granted by this court. So that is really the answer insofar as same basis, that's not? Yes, you can. Yes. So on that basis, I'd like to address the following topics. I have 7 topics that I'd like to address. The first one is the jurisdiction of this court under section 172. So that's the so it is the jurisdiction of this court under section 172, because we know that the submission by the applicant is that they are locating this entire application under section 172. The second topic is the unreasonable delay, and the third topic will be the agency. And when I give you the agency, and we are sending out in our bit of argument that the applicants will respond to agency, they might pick up to say that we are saying that we are an aggrieved party is entitled to come under 172 on an urgent basis before this court. That is not a contention, neither is it in this case that that can happen. We are very specific about the relief that is sought as a primary relief, but that does not fall under the urgent circumstances set up in section 172. Then topic 4 will deal with the on-the-ground principle and the Malaysian judgment. And when I deal with this topic, I will similarly deal with the declaratory relief sought, whether a case has been laid out for it, the setting aside of the ministerial determination, the setting aside of the adoption by the ECN to use EVMs in elections, and I'll also deal with the relief of setting aside the elections and whether the applicants have made up a case for the conduct of fresh elections. So under topic 4, I will deal nicely and move now on the merits of the application as it stands. Then topic 5, I will deal with the irregularities. I'm mindful to the court that in his oral submissions, Mr. Gauntlet did not rely on the alleged irregularities to impugn the elections. But he nevertheless said in his opening address that anything that he does not argue does not mean that he has abandoned it. So I still have to deal with the alleged irregularities in order to demonstrate to the court that the applicants have hopelessly failed to make out a case for the setting aside of the presidential elections based on irregularities. Then topic 6, I'll deal with remedy, and last I'll deal with the issue of cost. So let me start with the first topic of jurisdiction. As a point of departure, this court has previously adopted the legal principle set out in Shiva versus Transnet, which is a constitutional court judgment of South Africa, that jurisdiction is determined based on the pleadings and the relief that is sought by the party. So in this case, the applicant comes to this court under section 172 of the Electoral Act, and our learned friend has already read that section, but what I wish to mention is that it seems to be common cause, or we and the applicants are on the same understanding of section 172 of the Electoral Act, that it deals only with matters which this court has exclusive jurisdiction, and that's the important part. So, section 172 does not deal with matters where one may argue concurrently. So Mr. Bamford has made it clear also in his submission that under Section 172 is circumstances under which the court has exclusive jurisdiction. And he said so when trying to answer the question from Justice Ndabile, also from the question from Justice Naik. And of course, his submission is correct that Section 172 confines itself to exclusive jurisdiction. When you look at, for instance, first, that it must be in relation to any challenge relating to the return or outcome of the elections, meaning that it can only be invoked when the elections have happened and you are challenging the return or the outcome. So that is a jurisdictional fact or factor. Or it must be in relation to review the electoral material in order to mount a challenge to the presidential outcome. So now, this provision must be read together with Article 79(2) of the Constitution. When you look at 79(2), it reads as follows: the Supreme Court shall be presided over by the Chief Justice and shall hear and adjudicate upon, but unlike the court to underline, is appeals. Because that is the first jurisdictional fact, emanating from the High Court, including appeals which involve the interpretation, implementation, and upholding of this Constitution and the fundamental rights and freedoms guaranteed thereunder. So the first part of Article 79(2), it tells us in simple terms, this is a court of appeal. Then the second part, it then says, the Supreme Court shall also deal with matters referred to it for decision by the Attorney General under this Constitution and with such other matters as may be authorized by Act of Parliament. So today we're not dealing with the first part where the Attorney General refers the matter to this court, because the Attorney General has not done that. So we're dealing only with the second part, which is, and with such other matters as may be authorized by Act of Parliament. And one such matter is the one contemplated by Section 172 of the Electoral Act, which must be a challenge to the outcome of the presidential election. Now the question that was asked to Mr. Bamford by Justice Nkabinde was in relation to prayer 2 and 3, which in fact Mr. Bamford considered that prayer 2 and 3 are in relation to the conduct of the minister when putting into operation the Electoral Act 2014, in that he severed Section 97. And that is what we're challenging. So now we're saying that this, on a proper interpretation of Section 172, does not relate to the outcome of the presidential elections, because it relates to the promulgation by the minister in 2014 of the Act itself, and the whole Act except 97.3 and 4. So once the court agrees with us that prayer 2 and 3, which Mr. Bamford say that are the primary relief, fall outside 172, and this court, on a proper interpretation of Article 79, sub 2, the last part of it, does not have jurisdiction to hear it as a court of first instance and final recourse. And we should make it very clear, because the applicants were trying to conflate the issues here, that we are saying that the jurisdiction of this court is ousted completely in respect of class 2 and 3. That has never been the submission, and is not what is for sure in the papers. What we say that the relief sought in class 2 and 3 is a relief that the High Court has the competency to grant. And the answer is in Article 80. If you look at Article 80 of the Constitution, when you look at Article 80, it deals with the powers of the High Court. First it says, I'm not going to read sub-article 1, but I'll read sub-article 2. The High Court shall have original jurisdiction to hear and adjudicate upon all civil disputes and criminal prosecutions, including cases which involve the interpretation, implementation, and upholding of this Constitution and the fundamental rights and freedoms guaranteed thereunder. The High Court shall also have jurisdiction to hear and adjudicate upon appeals from lower courts. So, Mr. Bamford, on a question which came from the bench from Justice Nkabinde, considered that insofar as class 2 and 3 are concerned, it is a constitutional challenge. So the High Court is clearly empowered by the Constitution, in this Article 82 that I've just read, to grant the type of a declarator sought in class 2, and also the setting aside of the ministerial determination, because the applicants say that it is a constitutional challenge. The mere fact that the applicants say that our ultimate objective is to accept the outcome of the elections is at no moment, is neither here nor there. The relief as paid for is a standalone relief which seeks to declare invalid and unconstitutional that determination. So we submit that this court is not the right court jurisdictionally to adjudicate this matter as a court of first instance and final recourse. And of course we have to look at the importance of the matter. The applicants seem to say that this court must exercise its inherent powers because it's an important matter. But this court has already said before that the High Court is better positioned to deal with such important matters which have constitutional implications. In fact, that this court will benefit from the wisdom that will be derived from the judgment of the High Court, so that when the matter comes here as a court of appeal, it has that benefit. So that principle is very important. In fact, in paragraph 75 of Run for Democracy, that's now the 2013 one, this court has actually emphatically said that this court should be very, very, very slow to assume jurisdiction as a court of first and final recourse to deal with matters, and it is matters of this nature. In fact, when I refer, because there were 5 hours comprehensive case of arguments, and we're also making the same rider as the applicants have done, that anything that I do not cover in the submission, it still stands because when we have set it out in our heads of argument, but I simply like to say to the court that this court should simply, on the basis of the interpretation of Section 172, find that this matter belongs to the High Court because it's a constitutional challenge and it is a primary relief that is sought, and depending on how they have pleaded their case, as Chira say, it may also go to the Electoral Court under Section 168 of the Act. If you can look at section 168, and that Justice Minor will answer the question that you posed to Mr. Gauntlet about why are you not going to the High Court, and then he kept on saying that, well, the High Court will not have jurisdiction. But in fact, what he did not say is that the Electoral Court will not have jurisdiction. Of course, depending on how they plead their case. If you look at section 168, which deals with the powers and functions of the Electoral Court, the Electoral Court, unlike the Electoral Tribunal, is not only confined to dealing with matters pre-elections. It is empowered to deal with matters pre- and post-elections. And if they wanted to locate their case within the Electoral Act, nothing prevented them from going to the Electoral Court and plead their case there. We can see in section 168, subsection 1, which deals with the powers. It hears and determines appeals against decisions of the Electoral Tribunal. It reviews decisions of the Electoral Tribunal. Remember, Chief Justice, prayer 4, which we sought clarity from the Gauntlet account, is to set aside the decision of the Electoral Commission to adopt voting by EVM. That is rightly located within the Electoral Court. If you read the founding papers, no answer is provided as to why they didn't start at the Electoral Court and review that decision so they can set it aside on whatever grounds that they can allege. And C, adjudicate and decide any matter concerning any contravention of this Act. That's the Electoral Court. We are told today that, well, we couldn't go anywhere else except to this court because we are dealing with the decision of the minister, and it is unconstitutional because it was not empowered to sever section 97, and in any event we couldn't go anywhere because we are linking that decision to the outcome of the presidential election. We can only come to this court. All that submission has no merit, has no basis at all if one has regard to subsection C, because this Electoral Court established in terms of section 168 is empowered to adjudicate and decide matters relating to the contravention of this Act. And one of them that they say that has been contravened, they say that section 97 has been contravened and severed. So the answer that was given in response to the question from Justice Mahinga is no answer whatsoever to say that we could not go anywhere. So now we know that in terms of...
I don't think that section's been contravened if it's not been put into operation. That's what the point is, that how it was put into operation. How has it been contravened in its present form?
Yes. So actually then that makes their case even worse, because I'm going to come to that. Because that's what I say. So on the one hand they say the Act has been contravened, and when you look at what is it that they say has been contravened, they say that it's section 97, 3 and 4. Then on the other hand they say that has not been put into operation. But it makes their case even worse, so but I'll come to that. So all what I'm pointing out.
But I also follow up on what my brother is saying in this regard, Council, the key point that the applicant is stressing here relates to the constitutional issue that the conduct, by conduct, of selective promulgation, the minister has violated the Constitution. Now, we know that the minister and everyone else, including me and you, are obliged to comply with the Constitution of Namibia. Look at Article 5. Protection of fundamental rights and freedoms. Look at Article 25.
Yes.
Article 25 deals with enforcement of fundamental rights and freedoms. And we know from the pleadings that once we find that by his conduct of doing what the applicant challenges, the minister acted against the Constitution in doing what he did, that clearly will result in a declaratory relief they seek. Is that not so?
Remember Justice, remember you're already ahead of me.
If we find that indeed the minister ought not to have done what he did, will they be entitled to the declaratory relief they seek in paragraph 2?
Not necessarily.
As a matter of law?
Not necessarily. I'm going to come to that when I deal with the declarator. At the moment, I'm still dealing with jurisdiction. So, I hear what Justice Nkabile is saying about what they want the court to do with a declarator against the conduct of the minister. But at the moment, I have not yet come to whether a case has been made out for that. So that's why I was saying that Justice Nkabile, you are ahead of me in that respect. I am going to deal with that.
So you may as well deal with it now.
So at the moment,
yes,
I was simply focusing on the jurisdiction point by referring the court to the various provisions of the Constitution, the provisions of the Electoral Act, which deal with jurisdiction. So then that's what I'm dealing with. But accept that when I deal with a declarator, then I have to answer the question. But let me briefly answer it this way, but I'm still going to return to it. So I'm not waiting the right not to return to it.
Yes. But let me piggyback on my brother's question, just to make it clear. The case is that the minister acted inconsistently with the Constitution.
Yes.
Correct.
That's the rule that is sick, yes.
Yes. Now, if that is the case, if we so find that is the relief that you're going to argue about later, but we are dealing with jurisdiction here. Now, if you look at it, let's even suppose that we are not dealing with section 172. Let's for a minute just put aside section 172 and we look at the democratic principles in terms of the Constitution of this country. Bearing in mind that the voice of the electorate finds expression, meaning, and content in the election to vindicate those rights in 1717.
Yes.
My question to you against that background, will it be in the interest of justice or even the public interest if you follow agricultural union to unsuit the applicants?
Yes, of course, one will have to.
Public interest, interest of justice, the very important, historically denied rights. Not only here, but in South Africa. And given the jurisprudence that we know, would it be appropriate in all those circumstances to unsuit a party? Interest of justice, public interest, democratic principles, issues of governance, all those issues which seem to me very important to vindicate the rights of the people of Namibia. Can we simply close the door of the court to them and say, get out of here, I don't want to listen to you?
Absolutely. The court will be perfectly entitled in the exercise of the discretion to close that door, and it has done that before. The court looks at various factors and takes them into account in relation to the papers that they stand, and of course we're going to deal with it when we deal with the declarator and the relief that they seek. So the court has a discretion, it's a discretionary power that the court has After the court has found that it has jurisdiction, then it moves to the next and it considers whether a case for declarator has been made. And once it finds that a case for declarator has been made, it then comes to the next step, which is declaratory relief is a discretionary remedy, and it considers whether this is an appropriate case to grant a declarator. After that, it goes to the next step again, which is now an appropriate remedy, and hence then Justice Ndabile, you have also referred to Article 25 of the Constitution. So it is a step-by-step approach, and of course, the short answer then to your question, Justice Ndabile, yes, once the court finds that it has jurisdiction, which of course then it still has to determine, it will then determine the case on the basis of the declarator and the case sought to be made out in the papers, and it will grant that case, that prayer if it is satisfied after exercising its discretion on whether this is an appropriate case to grant the declarator and move to the other steps. So I accept that. I mean, that is really the law and one can change it. So that one is accepted.
But I also just came out also in relation to this discretionary power that you were talking about. In relation to the declarator.
Yes.
My understanding of the declarators of declaratory relief that the litigant might seek before the court should not be confused. There's one aspect that deals with a challenge to the law or to the conduct, in terms of which the law or the court would have no discretion if it finds that there has been a violation, inconsistency, to grant that relief. That is a non-discretionary declaratory relief. Authorities are clear on that. And there is another instance where the court can grant declaratories in relation to constitutional remedies. Now, the one that I alluded to is the latter, where the court has discretion. Now, given the previous case and the declaratory relief sought in paragraph 2, this court has no discretion.
It has, Justice Nkawinda. Article 25. Article 25.
I beg your pardon?
Article 25. So this case falls squarely under Article 25.
I just want to clear my mind.
Oh, yes.
Does the court, this court, have a discretion to grant or not grant the declaratory relief sought in paragraph 2?
Yes, it has a discretion. It is a discretionary one already embodied in Article 25 of the Constitution.
Why is it discretionary power?
You know, this
There is an alleged violation of the Constitution and the law.
yes, that's a fundamental right. A fundamental right.
Please, listen. I'm not talking about fundamental right. I'm talking about the conduct that is alleged to have been inconsistent with the Constitution and the law.
Yes.
Now we know from jurisprudence, I don't mean to refer to the cases now, that we have to separate the two. We have to differentiate between different declaratory reliefs and not conflate. The one deals with the form that I mentioned, where the law or conduct is alleged to have been inconsistent with the Constitution, in which case there's no discretion. And the second is in relation to constitutional remedies, in which the court does have discretion. And we seem to be emphasizing the latter. We are not there. We are not dealing with the latter, we are dealing with the former. So, in my opinion, and the way I understand the jurisprudence in the law, this court in this matter, in making a determination in relation to the declaratory relief sought, does not have the discretion. We have to find whether or not there is such inconsistency, and if so, declare the conduct invalid.
Now I understand when Justice Kavina, I understand the question properly. Initially, I thought the question was already moving to the remedy. So I understand the question, but the question is focused on the declarator itself.
But dealing with jurisprudence,
Yes, dealing with jurisprudence. Now, on that point, Justice Kavina, you absolutely.
dealing with jurisdiction.
Yes. Now, I'm saying that I know I'm dealing with jurisdiction, but I'm now addressing the questions which emanate from the bench, which do not really deal with jurisdiction. So I'm saying that I now understand your question properly, that your question is in relation to whether the court has a discretion to grant a declarator. So I'm saying that there, Justice Kadini, you're absolutely correct, especially in the light of the South African authorities such as OIPay, that once the requirements have been established for a declarator, the court does not have any discretion, but it has to grant a declarator and move to the next step of the remedy. So there are exceptions.
But not only in relation to South African authorities, but also in relation to the constitution of Namibia. If you look at those provisions.
Which provision will that be?
Constitutional obligation.
Yes.
In section 5, article 5.
Yes.
Constitutional obligations are all and sundry in relation to article 25. So, I think it is important. I saw this point.
Yeah, no, I'm not putting it in dispute at all. That's why I said I misunderstood the question earlier. Yes, so I'm not putting it in dispute. Yes, that's right.
So, you agree we don't have this question?
No, I agree that the court will not have a discretion insofar as granting a declarator. Yes, that's right. Then it will move to a remedy, and I've said that all pay is referring to that, and it has been referred to them by this court as well. So let me just conclude on jurisdiction that we are in agreement with the applicants that Section 172 deals with matters upon which this court has exclusive jurisdiction. So it means that in order for this court to find that it has jurisdiction to adjudicate this matter, it must find that it has exclusive jurisdiction to grant prayers 2 and 3 and 4, and that the High Court and the Electoral Court are ousted. So that is really our submission, because we are on the same page. There is no debate among us about whether it is exclusive jurisdiction or concurrent or otherwise. So we are all arguing that 172, it focuses on those matters upon which the court has exclusive jurisdiction. So we say that we refer the court to Article 82, we refer the court to Section 168 of the Electoral Act to show that both the High Court and the Electoral Court have jurisdiction. We ask that this court should simply decline to deal with this matter, and of course, the applicants will not be non-suited because they can always, as Justice Manga said, go to the Electoral Court or the High Court again. So that is so far as our point.
What happens, can I just ask a brief question, what happens if we decide that to grant the relief of 5, the basis of 2 and 3 not make according to the effect?
Justice Mas, can you repeat your question? There's some echo in the room.
What happens if the court decides to set aside the election, the outcome of the election on the basis of electronic voting without verifying the trial, without making a declaration? Surely we could do that.
No, the court can't do that. In fact,
this court cannot do that.
No, it can't do that because there is authority. There is authority of this court. I think my juniors will find it that you can't because in order for the court to set aside elections on the basis of non-compliance with a paper trail, it will be because of non-compliance with Section 97(3) and 4. Because a paper trail is a statutory provision. So the court will then say that it is without a paper trail in violation of Section 97(3) and 4. And we know that 97(3)(4), not 97(3)(4), the Electoral Act has been promulgated in 2014 by the Minister, and that decision has not been set aside. And there's authority of this court that you can't actually ask for some form of a declaration, and then when you are sitting with a decision which you have not actually upset or which you have not set aside. So you can't do that. Yeah. No, you can't do that. I mean, the marginals will find. But also, yeah, there is that authority. Or, I mean, the same court. So what I'm saying, well, either this court or high court. But the point that I'm making is that if this court were to move straight to prayer 5, then this court will now be moving on the premise which is not what the parties have come to this court then about. So we have come to this court and we have been told clearly that we are actually dealing with this primary relief which must lead to the consequential relief. So Justice Moss, we just have to bear in mind that prayer 5 is consequential. And that question has been answered 5 times by Mr. Gamble. But it was only when he was being probed that he said that, well, to us it doesn't matter what we do, but it matters because the applicants are not here before court alone. They're here then with the respondents whom then they've invited that this is the case that we are taking to court and this is the case that we have answered. So the consequential relief follows from the main relief. So you can't get a consequential relief when you are not entitled to the main relief. So to do so will be to really avoid the fact that we are sitting with a determination that was taken in 2014 and which has been in existence for 5 years, and upon which elections have taken place in 2014, by-elections took place in 2015, and by-elections then have always been taken place on the basis of the same determination. We'll be running away from there. But the applicants appreciated that they can't run away from there because of the overall principle. But that decision stands until it is set aside by court. That's why Mr. Gamble is at pains to say that I still want that declaration. Because it is important to his clients. Without that declaration, he's not able to move to the elections. Yes, I accept that if the elections were impugned on the basis of irregularities, then prayer 5 is a standalone prayer. So we've got to make that distinction very clear. And we make it very clear both in the answer affidavit and in our heads of arguments. We take no issue with the fact that an aggrieved party can approach this court to impugn the outcome of the presidential elections, but the outcome will be impugned on the basis of the case period. So the case that is pleaded and what Mr. Gamble has informed this court is that forget about irregularities. I am not really saying that you must impugn these elections based on irregularities. I'm saying that you must impugn these elections on the basis of non-compliance by the minister with Section 209 by enacting the Electoral Act and severing Section 97. So that is the case that he says that we must deal with. So that's the answer then to whether this court will be competent then to move straight to prayer 5 and set aside elections without the declaratory orders in prayers 2 and 3. Oh, when my junior then has given me a case, I just want him to point to the specific paragraph in respect of the question of this setting aside of the decision. Sorry, Chief Justice.
I was saying that you don't want to deprive people of their right, fundamental right to food. So you don't completely break for that.
We accept that right to have something to give us the strength.
Okay, good luck, and you should let other parties too.
As a public.
listening. What did he say? My sister, she's not an American.
Staying with us. We're busy with the electoral challenge brought about by the independent presidential candidate Dr Panduleni Itula. We're breaking for lunch at the moment, as was announced earlier, and we resume the live broadcast at 2:15 on all the Facebook Live platforms of the Namibia Media Holdings. Of course, it will be Kane, Alderman at Sightseeing, Namibian Sun, Vincent Express, as well as Iranga. Thank you.